Good morning, everybody. Happy Thursday. Welcome to the Courtroom Files Live. As seems to have been the trend this week, let's start with Judge Dad.
To the charge of operating while impaired on July the 10th. I referred him for a screening and assessment. Have you had the opportunity to review the report with him?
Yes, Your Honor. There's a couple things I wanted to shed some light on as it relates to the PSI report.
Okay.
So under the page 2, under the drinking style and treatment history, it says he's never been involved in substance abuse treatment. So that's actually not quite accurate. He's had a substance abuse evaluation with Serenity Therapy and Raj Mehta. So I just wanted to make sure that that's correct.
Okay, I'll modify the report in that aspect.
And also, as regards to the recommendation, he's actually already completed Mothers Against Drunk Driving Impact Panel, and has actually donated $500 to the program. So I just wanted to make sure you're aware of that.
He donated $500?
Yes, in addition to attending the program.
Okay, well, that's awful kind of you.
And the rest, I just had the rest for allocution.
Okay.
So he's 38 years old. He's a very close relationship with his family. He's a mother, father, 2 sisters. He actually is from this community. He graduated from Southgate Anderson High School in 2004. He's married. He's the father of 1 son, a 1-year-old. He graduated Michigan State University with a bachelor's in science. He does have a criminal offense. He has an MIP and a no tolerance OWI from his time at MSU. But he has since overcame those challenges. He's a certified therapeutic recreational specialist, and he owns his own practice called Semeco Recreational Therapy. Did I say that right? Semeco. And it's actually pretty inspiring, Your Honor. He's really, it's really can call him a modern day miracle worker. So he works with people who have had traumatic brain injuries and who have several impacts on their day-to-day lives, and people who have like cerebral palsy and different patients with very debilitating conditions. So one example that I thought was really moving to me, so he had a patient who could barely walk more than 100 yards without a wheelchair. And Mr. Hargis has worked with this person over the course of the year, and at the end of that year, this person was, what, 92 years old?
No, that was a different.
Okay, so this person, over the year of working with Mr. Hargis, went from not being able to walk 100 yards to walking the whole Mackinac Bridge on Labor Day.
Nice.
So this person, incredibly smart person, incredible asset to his community, and has just been a service to others. As far as the incident that brings us here today, it's definitely a low moment for Mr. Hargis, but I just want to point out a couple of things. He's been cooperative with law enforcement. No one was injured during the incident. He has taken responsibility and accountability for this incident. Like I mentioned earlier, he's already completed the Mothers Against Drunk Driving Impact Panel. He's donated $500 for that cause. He's completed a substance abuse evaluation, and as part of that evaluation, completed a substance abuse education prevention program. He continues to do 12-step meetings. He's had perfect bond compliance. As far as his conditions for this court. Also, with the impaired conviction, he will have driver's license restrictions, so it's already taken care of by statute. And so with that in mind, we just asked the court to adopt the recommendation with limiting testing requirements and driving restrictions, so Mr. Hargis can continue to serve his community and his patients.
Okay, thank you. Sir, is there anything you'd like to say?
Yes, Your Honor. I'd like to apologize to the citizens of Flat Rock and Gibraltar for putting them at risk on May 17th. I'm well aware of the potential consequences of my actions, as some of the patients that I see are a result of an alcohol-related motor vehicle accident. I'm very sorry for my actions. I'll do anything that I can to make amends and make sure that this never happens again.
Okay, well, all right, good enough. Well, I'm impressed. I'm impressed that you're taking responsibility, and just overall what I'm reading here. I'm going to place you on probation. I'm going to make it for 10 months. You cannot leave the state without the consent of the court. You cannot violate any law or ordinance. You change your address, your place of employment, or home telephone number, you do have to notify probation. You have to report as directed. No alcohol, no marijuana, no illegal drugs. You're not to purchase, possess, or consume any one of those. Kratom, poppy seeds, and CBD oils are prohibited. Consuming food or other items containing those substances will be deemed a violation. In order that you submit to chemical testing, PBTs and ETGs, I'll go along with that monthly. I'm going to order the victim's impact, but all I need you to do is provide proof. I made a note, attended, provide proof. So you just have to provide us with proof that you've attended that. Go to AANA at least once a week until you're in outpatient treatment. Once you get into outpatient treatment, you don't have to attend AA or NA any longer. I'm going to order 3 days jail credit, 1 serve 2. I'll let you serve those on the by way of community service. So 2 days community service in lieu of jail. And I'm going to give you until September 10th. So 16 hours community service by September 10th. $300 in fines, $250 in costs, $75 victim's rights fee, $50 justice assessment, $675. Probation fees are $200 for $875. You have cost of recovery of $150, bringing the total to $1,025, and then you have a screening fee of $60. Your total is $1,085. If you violate, your probation could be revoked. You could be incarcerated for 93 days. You have 21 days to appeal, and you have 14 days to apply for a court-appointed lawyer for purposes of appeal. Do you understand that?
Yes, Your Honor.
All right, so we have $1,085, and you can go down the hall. Can you pay that today, counsel?
Yes, sir.
All right, anything else? Any questions, either one of you? Anything?
Nothing for me, Your Honor.
Anything?
No, Your Honor.
All right, again, I cannot tell you how sorry I am we got out here so late. The meeting just went longer than I thought. My apologies. Good luck. Thank you.
Your Honor.
Thank you very much. Noah Russell. Do we have Noah Russell? Noah Drake Russell?
They're on Zoom, Judge.
Yeah. 17M705-9662FY. All right. Mr. Russell, your name?
Noah Russell.
Counsel?
Your Honor, good morning. Nader Nassif, P72557, appearing with and on behalf of Mr. Russell.
Do we have the detective out there on this? This is state police.
No, Judge, this was an older case. I couldn't get a hold of anyone.
All right. So, counsel, for purposes of arraignment, how does he wish to proceed?
Your Honor, we'd wait for more readings, stand mute.
All right. So I'm going to advise you of your rights, sir. You have the right to remain silent. You do not have to say anything. If you say something in or out of court, whether orally or in writing, it can be used against you. You have the right to be represented by your lawyer, not only today, but at all subsequent court proceedings. Also, if you choose to submit to questioning with law enforcement officials, you do have the right to be represented by a lawyer at that questioning. Do you understand that?
Yes.
You have the right to a probable cause conference within 14 days. You have the right to a preliminary examination within 7 days thereafter. The probable cause conference will take place on August the 5th. That will be at 9 o'clock in the morning. You'll be in front of Judge Hessen. And then preliminary exam will take place August the 12th at 11 o'clock in the morning, okay? So August 5th, 9 o'clock, August 12th, 11 o'clock, preliminary exam. The preliminary exam is to this count, the people have to show that the crime was committed, excuse me, and that you were the one who probably committed the crime. If they prove that, you will be bound over for further proceedings to the Wayne County Circuit Court. If they fail to prove that, then that charge would be dismissed. Do you understand that?
Yes.
All right, so counsel, I'll listen to anything you have to say regarding bond. Where has your client been on this?
Your Honor, my client is a resident of Ohio. He lives in Southern Ohio. This was a case that he was visiting and never was informed or never knew, obviously, about any felony charge. The way that he found out about this is he was looking to get his insurance license in Ohio, and through the background check, this came up. Once he learned about this, he immediately retained counsel. We've been working through that at this point. So Your Honor, I would ask for a PR bond. I expect that he will abide by all court orders. And Your Honor, frankly, there are some issues with the case itself, being that the laws have changed regarding marijuana as well. So I would ask for a PR bond with standard conditions.
What kind of a record does he have?
No other record, Your Honor.
$10,000 personal bond. You can leave the state to go to Ohio. You cannot violate a law. You must appear in court as directed, no alcohol, no marijuana, or illegal drugs. And we're going to give you those dates. So you just have to, you can appear by Zoom on the 5th. You do have to appear in person, obviously, for the exam. Okay. Anything else, counsel?
Nothing further, Your Honor. Thank you.
Any questions, Mr. Russell?
Nope.
All right. Best of luck to you. Thank you.
Thank you, Judge.
Thanks. Chantel Ruel Williams, 25. Let me see. 25F2444198. Your name?
Chantel Williams.
Okay, you need time to pay?
Yes, please.
How much, do you have anything today?
No, sir.
When can you pay this?
Can I be given 2 weeks?
Yeah, do you want to set up a payment plan? What do you want to do?
Yes, that's what I was initially trying to do.
Okay, how much can you afford to pay? You just tell me when you can pay it. If you want, we'll set up a payment plan weekly or bi-weekly.
Can we set up a payment plan bi-weekly?
Sure. And you want to start in 2 weeks?
Yes.
How much can you pay?
Can we do 50?
Sure. You pay $50 bi-weekly, okay?
Thank you.
And I'm going to start this beginning. You did the right thing coming in, by the way. I wish everybody would do this. You pay 50 bi-weekly starting August the 8th. If you don't have the money, just call the court. We'll go on Zoom, or you can walk in here on or before the due date. I'll be more than happy to give you an extension.
I appreciate that. Is there a way I can just mail the payments?
Yeah, they'll explain everything down the hall to you, okay?
One more question,
Sure.
I was wondering, is there a way to maybe ask for the fines and the fees to be taken off?
Do you have insurance now?
No, I'm working on it.
Why didn't you show up here initially? That you had a extra fee. Why didn't you show up?
Initially, honestly, I was not given notification. And
Where do you work at?
I work with the airlines, but it's not a lot of hours.
I'll tell you what, I'll reduce the fines and costs. I will do that for you. Reduce to $185, okay?
Thank you, Your Honor.
All right, best of luck.
Thank you.
Good luck. Thank you.
Let's go to
Good morning once again, everybody. Welcome to the Courtroom Files Live. So for our nature stuff this morning, whoop, I don't have it set right. Hang tight. It helps if I have it set properly. There we go. So for our nature stuff this morning, Ellie chose birds today. So we'll watch some birds in between things. This is from, I don't know where this feed is from. I'll figure it out. But before the show today, I pulled that up on the TV, and Ellie was just obsessed, so I figured that everybody else should be able to see it as well. Let's go to the fastest talking judge in the industry. We'll go down to Wade Mercer and watch him power through first appearances.
But that case was dismissed. I did see that. So I'm going to see if the attorneys have any additional information before I set you a bond. I think I may have told you your girlfriend is in the courtroom. Mr. McDaniel, anything on behalf of Mr. Lovett?
Thank you, Your Honor. We'd just like you to take into account the, the ongoing disputes between him and his brother, and that last one was also an accusation by the brother. And they have a property dispute that's been going on for years, and the brother's been he's tried numerous times to kick him out of the house civilly, I believe. And so just to take those things into consideration, because this is all, based on someone that has a bias, the accusations from.
Okay, Mr. Mitchell.
Nothing, Your Honor.
Yeah, see, none of that's in the complaint, Mr. McDaniel, so that's all new to me. The prior dismissal by the state attorney's office gives you no information at all. It just says the state cannot prove the case beyond a reasonable doubt. So you're saying that the prior case, the evidence against him in that case was also the same person that's accusing him of not living there now?
Yes, sir.
Yes, Your Honor. And I'm going off what he's telling me on that part of it. I haven't looked at that case, but it, you know, with them dismissing it, it sounds legitimate. And I and just reading the
So,
complaint.
Mr. McDaniel,
And having an animosity between his brother, you know, I mean, you know, the amount of things that, you know, he was saying to the deputies, you can kind of tell he was.
is there a pending civil case or just some kind of family dispute on some property?
Y'all got
Is there a
pending
lawsuit
cases
I can
now?
look at?
No.
You said you've been in front of Judge Murphy.
Yes, sir. I've been in front of you before. He tried to evict me out the house and you said he was in the wrong court. He put me in court, tried to get me put out the house.
All right, give me
And
a
I've been
second to look at that,
before.
Mr. Lovett. Mr. Lovett, hang on
Sir.
just a second. I'm gonna try to pull that up.
Yes, sir.
That may refresh my memory about
Mhm.
the case. I see hundreds of cases per year, so we'll see if I can find anything on that. There is an open case, 25-121CA. That would be a circuit civil case involving plaintiff Donnie Lovett and defendant Glenn Lovett.
I don't know about them.
Mr. Mitchell, is that the same person that's in the complaint this time, Donnie Lovett?
Donnie Lovett is the brother in question,
Let's
yes.
see what that's about. Is Ms. Simpson representing one of you in that lawsuit? You or he? Who's she representing?
Donnie,
Him, because he didn't know about the lawsuit.
I don't even know about it.
Your Honor, I can clarify a little bit more about the previous charge of the same kind that was dismissed.
Okay.
That one was based on, designation for months to register, saying that he failed to comply with registering in January, April, and July and October. That was the basis of the previous failure to register. So
Do you know
And I
anything
can-
about the dismissal, why it was dismissed? Because the dismissal itself doesn't tell me at all.
all I can see is just what you have right there, which is we can't prove it beyond a reasonable doubt or there is insufficient evidence.
Mr. Lovett, the case that you say that y'all were before me on, how long has that been?
Oh, maybe a couple of years ago. And he.
In
brought a
Jackson?
case,
It was in
civil
Jackson
case.
County?
Yes, sir. In Jackson County, he brought a civil case for you trying to get me put out the premises. It was also another case before another judge where she dismissed, where he tried to get me put out the property. He's not mentally stable, Your Honor.
Okay. Yeah,
When-
13 years ago, there was a case. That's probably why I can't remember it. 13 years ago, there was a case with you and he, and I I signed a dismissal, I believe.
That's
Let me
it.
see what that dismissal says. I don't even know what kind of case it was.
That's civil.
Yeah, it's 2012-207CC, so it's a county court case. Well, I wasn't even the judge in 2012, but if it got resolved in 13, I would have just taken the bench in early 13. It's so old, computer's having a hard time pulling it up. No, it was dismissed in 12, so that wouldn't have been me. That would have been dismissed when Judge Hatcher was here.
Okay.
So let's see if there's no
Yeah.
clerk's notes or anything back then. So unless I can get this dismissal to open. Yeah, because it's got the little image box.
Done.
But it won't open it up.
Available to us a decade ago.
Okay, so Mr. McDaniel, I'm not going to ask your client this question, but Mr. McDaniel, your position is he's still living in that residence now and that the brother misled law enforcement? Am I summarizing your position, Mr. McDaniel?
That is our position, Your Honor.
Yes,
Yes, sir. I don't say anything.
Okay, yeah, I don't want him to say anything. Ma'am, in the courtroom to the girlfriend, do you know anything about where he lives, ma'am? Can you come up so I can? So the dismissal finally pulled up and it just says the court has no jurisdiction, which is what Mr. Lovett said. So here's the question, ma'am. When law enforcement went out there yesterday, are you familiar with what his brother told law enforcement?
I was home. I wasn't there.
Okay, so let me tell you what he told law enforcement, because you may know something about this.
Mhm.
Not when they went out there yesterday, when he went out there when the charge occurred. Because some of this mentions, I believe it's talking about you. 25-199 CL. Okay, and what's your name, ma'am?
Sylvia Dozier.
Last name again?
Dozier.
Dozier, D-O-Z.
I-E-R.
I-E-R, Miss Dozier.
Mhm.
Miss Dozier, what I want to do is I'm going to read to you this part of the complaint,
Mhm.
and you're his girlfriend, correct?
Yes.
Because this says he's living with you, and if that's
Mhm.
not true and you can testify to that, then that's going to be something I can consider today. So what the complaint says is this. It says the officer was doing a check of registered sex offenders, made contact with Glenn's brother, Donnie, who is the gentleman they were having these lawsuits back and forth. I was informed Glenn was not home, that he comes and goes, and the last time he was at this address was Monday, 3/17. This date of the visit was 3/20. While speaking with Donnie, he provided the following information. Glenn has a girlfriend, name unknown, who resides in Madrid, Alabama. Is that you?
That's me.
Well, unless he's got two in Madrid, it's probably you, okay? At an unknown address. Glenn typically stays with his girlfriend at her home in Alabama months at a time and only stays at his listed address approximately 1 day a week. Donnie said this has been ongoing since Glenn was released from prison between 3 and 4 years prior to this interaction. Donnie stated Glenn has spent so much time incarcerated that he acts as if he does not care. Donnie swore this was the truth to the best of his knowledge. So what I'm gonna do is I'm gonna place you under oath and see if you can contradict that or confirm that. So do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth to help you God?
I do.
Do you know anything about that?
No, he don't stay with me. He stay down on Jerusalem Road, whatever his address is. But he don't live with me. He never lived with me.
Okay, so this part about him staying with you for months at the time is just not true.
It's not true.
Mr. McDaniel, any questions for this young lady?
No, Your Honor.
Mr. Mitchell?
No, Your Honor.
Thank you for coming, ma'am. Under the circumstances, Mr. Levitt, I'm gonna give you an ROR. It appears to me that there may be more to the story. Y'all got pending lawsuits, and the girlfriend, I don't have any reason to doubt what she's saying, but we'll let y'all figure this out at a later date. So I'm gonna give you a release on your own recognizance based upon what she's saying today, as well as what you've told Mr. McDaniel, and he's been able to relay to me. You're gonna get out of jail
Yes,
this
sir.
morning. That does not mean the case is dismissed. It means that you're
Yes,
gonna get
sir.
out of jail, and we'll let y'all figure it out at a later date. Mr. Levitt, do you have any
Yes,
questions?
sir. Yes, sir. No, sir. No, sir.
Ma'am, he can be picked up at the jail. Are you going to pick him up? Wish you the best, sir. Thank you, ma'am.
Thank you, sir.
Your Honor, I guess just for clarification, you did find probable
I
cause.
did find probable cause. There's
Okay,
probable
all
cause
right,
in
I
the
just wanted to
complaint.
make sure.
Proving it's another question.
All right, yeah.
Y'all may be able to. We'll see. Then we have Saritha Williams. Williams, good morning. Ms. Williams, you're here for an old charge of violation of county probation in case 2010-2465 CT. Ms. Williams, my understanding is that you've finally turned yourself in to try to get this old case resolved. Your son and a young lady with him are in the courtroom. Ms. Williams, I'm going to appoint the public defender's officer to represent you and ask that you listen to Mr. McDaniel, your attorney, and we'll see where we go.
Your Honor, I've spoke with Ms. Williams, and at this point in time, she's going to admit that she violated the probation, and she wants to talk to the court and try to give some, information to the court and plead to the court, I guess.
Okay. And so, Ms. Williams, I need to explain to you a couple of things. You're on probation for the charge of driving while license suspended. The allegation is that you quit reporting, didn't pay, you had fines remaining, and that you didn't get a driver's license. There's been a warrant out for you since August of 2011. So that's what you're accused of. On those accusations, you have the right to go to a VOP hearing. If you would like to go to a VOP hearing, we're going to schedule it. You have the right to have an attorney appointed to represent you, and the state has to try to prove, or will try to prove, that you violated the terms of your probation. You also have the right to waive that VOP hearing. If you waive that hearing, then you're saying, Judge, I'm not going to contest it. I've admitted to violate in terms of my probation, but there's some additional things I would like you to know. If you waive that right to the hearing, you're waiving your right to the hearing, you're waiving your right to call witnesses on your own behalf, and you're waiving your right to cross-examine the state's witnesses. Knowing all of that, you want to waive your right to the hearing and proceed with an explanation and a sentencing, ma'am?
Yes, sir.
Ms. Williams, I'm going to accept your admission that you violate the terms and conditions of your supervision, ma'am, and we'll find that admission is freely and voluntarily entered. So now let's move on to what the appropriate sanction should be. So I'm glad to listen to anything you want to tell me, ma'am, about these accusations.
Okay, when I was first placed on probation, I was living down here and my son was 2 years old in Georgia and he was having seizures and went into the hospital and I went back to take care of him. I did not come back and handle my stuff like I should have. I do admit that was where I was wrong. I come in last night and turned myself in and they told me that if I was to turn myself in and pay off what I owed, that I could possibly be released this morning. My son is he's graduating college Tuesday. I have a 9-year-old daughter at home and I have a job that they're expecting me to come back to because I was under the impression that I would just be gone for like 1 day. And he said that they were trying to give me 10 days, but my main concern is my son graduating college Tuesday and me not being there and my job, losing my job.
Okay.
But I do have the money to pay it.
The problem is I can't just let somebody show up and pay something, what we're talking about 14 years later.
Yes.
That's a problem, but I'm concerned about your accusation that your allegation that you were told something specifically. Mr. Goodson, you want to speak with her? Let's listen to Mr. Goodson. He's going to tell us about that conversation about what you were told if you did turn yourself in. And that is a factor that you turned yourself in, but let me see what Mr. Goodson's position is.
Miss Williams had called me on July the 11th and wanted to take care of her case. I had spoken to you that day and about the case. There was an amount, an arrearage of $413.50 of my fine and $180 probation fee, which is $593.50. I did tell Miss Williams, based on the conversation with you, there was a possibility that you would look at it the next morning, but I could not guarantee her that she was going to get out of jail. I said, if she can bring the money, that may help. She did. She called me Monday and said she was going to turn herself in this week. And then I told her to call me Wednesday to make sure you were going to be here Thursday. She called me yesterday afternoon and she told me she was on her way. And I told her she told me her son was going to be in the courtroom and that her son would have the money. But I did not tell her there was a guarantee she was going to get to pay. I said there was a possibility. So
thank you, Mr. Goodson.
Yeah.
So, Ms. Williams, the reason I don't ever guarantee anybody anything is I know nothing about your criminal history in the last 10 or 12 years until you get to court. We don't pull criminal histories on somebody that may turn himself in. We'd be wasting a lot of time if we did that. We pull criminal histories when someone turns themselves in. So when you turn yourself in, the criminal history I got this morning had a different date of birth. It didn't even have your date of birth. So I called the jail and said, this is not even her. Can I get a criminal history on the person you have in jail? Correct criminal history. When I got that criminal history, it appears you've been arrested at least 3 times while this warrant has been outstanding, those 3 times in the state of Georgia. Do you agree with that arrest record, or you disagree with that?
I believe it's been 1 time.
You think it's been 1 time? Okay, so let me look at the date of the warrant. It would have been August of 2011. So according to the criminal history the jail sent me, all of these are in Georgia. You've probably got maybe 6 or 8 or 10 arrests, but some of them were before this. So I'm only looking at the ones after this because I want to know if you stayed out of trouble and been a productive citizen. And what this criminal history shows after the date of arrest was Worth County Sheriff's Department on, let's see, this first one is a probation violation in Worth County Sheriff's Department, and the date of the arrest was, no, that one would have been before. So that would have been right before this. 2014 is the next one, 5/17 of 14, Worth County Sheriff's Department, possession less than 1 ounce of marijuana, misdemeanor charge. You remember that arrest?
Yes, sir.
Yes.
Okay.
That's her.
Then the next one after that was 4/22 of 19, which was about 5 years later in Colquitt County, Georgia, knowingly making a false statement pertaining to motor vehicle insurance requirements. Remember that arrest?
I've never been charged with that.
She don't know anything about that, Your Honor.
I've never been charged with that.
Is your middle name Diane?
Yes, sir.
Okay. According to your criminal history you have, and then another one in February 1st of 2020, Colquitt County, Saretha Diane Williams, simple battery. Remember that one?
That's the one I was,
That's her,
yeah.
Your Honor.
Okay. Then another one, 2/17/20. Actually, that's only 16 days later, so that could be the same charge. It's a probation violation, so it may be the same charge, just a probation violation. So that's, your history shows 3 arrests. So based upon the 3 arrests, I'm not inclined to just let you out and let you pay the money that you owed 14 years ago and say bygones are bygones. I mean, it took you 14 years and you've been arrested 3 times. So having said that, I think I'm gonna stick with the sentence. Now, I don't have a problem though talking about this college graduation thing. So I may be able to try to help you with that. So give me some information. Your son is graduating from where?
Southern Regional Technical College. My
When?
son is in the courtroom and he's graduating on
ma'am.
Tuesday with his business management degree.
Okay, so if I were to consider letting you out, I'm concerned about letting you out because I want to make sure you come back and finish the sentence. If I let you out to go to this, let me finish the question, ma'am. Wait just a second. If I let you out to go to your son's graduation, are you going to come back and finish the rest of your 10-day sentence?
Yes, sir. That was the whole point of me coming and turn myself in now, is because I want to get this behind me. Like, I don't want this hanging over my head.
Well, let me ask a question about that because I'm confused. Why would you wait to turn yourself in now? What prompted you after all these years to finally turn yourself in? You have to go somewhere for the graduation that's going to require an ID or something?
No, sir. I went and got a criminal background check. I had honestly completely forgot about this. And I went and got a criminal background check the other day and it was on there. And as soon as I seen it on there is when I called Mr. Goodson.
Okay. Where's the graduation at on Tuesday?
In Bainbridge, Georgia.
Okay. So it's just right across the state line. All right. So if I sentence you to what I'd originally agreed to this morning, which was 30 days in jail, let you purge and pay your court costs and fines after serving 10 days. But I also let you out to go to this graduation. When would you need to get out and when could you be back to finish your sentence, considering that you've got a job and I know you need to talk to your employer also?
Yes, sir. I would need to get out at least Monday afternoon so I could be there Tuesday morning.
If I let you out Monday and let you stay out for a period of 1 week before you came back to finish it, would that give you time to go to the graduation and try to talk to the employer and save your job, hopefully?
Yes, sir. What is the date? Do you know the date for that? Because my daughter also starts school and I want to be able to.
Okay.
Your Honor,
Is it just a second? I want to hear from you, but I need to get her question answered first. The Monday's date. I thought you were looking at calendar, Dawn. What's the Monday date? Monday's the 28th, and the following Monday would be the 28th and the 4th. That's the date you would get out, and you would come back on the 4th to finish whatever you had left, which would be roughly 5 days or so.
Yes, sir.
When does she start school?
I believe they start on the 3rd or the 4th.
Okay. Mr. Mitchell?
Your Honor, I was going to suggest an alternative, and again, this is up to you if you consider it. I don't think she's a flight risk. I mean, when she found out about this, she did turn herself in.
She's been gone 11,
well,
13 years, and you don't think she's a flight risk?
Well, considering that she's admitting the violation and wants to go ahead and serve the sentence, the alternative I would think is instead of having her serve the few days, get out and then come back and serve the sentence, she goes ahead and enters the plea, is granted like a conditional release or some small monetary bond, and then she can officially begin her sentence next week.
Okay. Thank you, Mr. Mitchell. Mr. McDaniel, anything else? Anything from your client?
Your Honor, I think a better alternative, and that's up to the court also, is give her 6 days in jail. 6 days, she'll be on her 6th day on Monday, and, but if the court feels inclined, I understand the court's concerned, and I completely agree with it, but,
I think with Mr. McDaniel, I think with Florida's game time law, I'd rather just do that and be done with it. What I'm going to do is I'm going to sentence you to 30 days in jail, but you can purge after serving 6 days instead of after serving 10 days. Okay. So let's do the math, Mr. McDaniel. Let's make sure I'm not messing anything up here because I want her out Monday. So she went in on a Wednesday. She went in on Wednesday, Wednesday, Thursday, Friday, Saturday, Sunday, Monday. She get out Monday morning. Okay. So ma'am, as long as your son pays that, my understanding was he was going to pay it, Mr. Goodson, and let's get that amount so we're on the same page with that amount. It's the same amount that you owed 13 years ago. I haven't added one dime to it. It's the same amount. And that amount is,
My understanding, according to Ms. Williams yesterday, the fine was $413.50. I assumed you were gonna make her pay the probation fee, which was $180 back then, so the total amount would be $593.50. Ms. Williams, you told me that your son would have that this morning, correct?
well, no, it wouldn't be the full 180 because she wasn't on supervision the whole time. She left early.
Okay,
So it'd only be the month she was reporting.
so $413.50 plus 90 would be $503.50.
So the purge amount is $503.50. I'm sentencing you to 30 days in jail. You can purge at any time, but you'll be released if the purge is made after serving a total of 6 days. And to be specific, you'll be released on Monday morning. What's that date again?
28th.
July 28th, 2025. Monday morning, the jail, when people get out in the morning, Corporal, what time do they get out of jail so her family will know?
We normally release them at 7:30, Your Honor.
So she
That
can
way it
pick up
gives-
7:30 next Monday, as long as that's paid. Is it your plan to pay that? So what I would suggest is you go downstairs and make that payment at the clerk's office. The clerk's office will then email the jail and say the money's been paid. That way you don't have to do it later. Monday morning, next Monday at 7:30, you can be at the jail to pick her up. Are you going to be able to pick her up? And that'll help her get to the graduation. She can deal with school and everything. All right. So if you wouldn't have turned yourself in, it'd probably just be a flat 30 days and that's it. With no getting out early, just 30 days. So I am taking that into account, ma'am.
Yes, sir.
Ms. Williams, do you have any questions?
No, sir.
To her son, do you have any questions, young man? All right. Congratulations on graduation from college. I wish you all the best. Ms. Williams, wish you the best, ma'am.
Thank you.
I think that's what I meant to say. She turned herself in, so that's what I meant with not a flight risk. She accepted her responsibility.
I understand. Thank you. All right. So the next person that has friends or family here is, we already seen no, we haven't. Sean Miller. We haven't seen Mr. Miller yet. Mr. Miller, good morning. Mr. Miller, your wife is in the courtroom, sir. You're here because you've been accused of one count of driving while license suspended or revoked knowingly. Mr. Miller, your wife has brought some documentation with her this morning and showed it to the prosecutor, Mr. Mitchell, so that may have kind of helped you somewhat. Let me see what the state's position is on bond or release or so forth, and then I'll see what Mr. McDaniel's thoughts are. Mr. Mitchell?
So, Your Honor, yes, she came in, she provided a certificate showing, that he attended the substance abuse class, showing the period of time that it lasted, and the seal was officially on there showing that there had been completion of the class. I pulled his license up on the FLHSMV website, and the only reason for the cancellation was for failure to complete that substance abuse treatment. So I don't know if it's just some type of error on the FLHSMV website or something like that, but there is credence to the fact that it seems like it was more of a unknowingly than a knowingly.
I don't know that that's accurate based on what Mr. Goodson's about to tell us, because
Mr.
the way
Goodson
that,
may have more.
listen to what Mr. Goodson, because he's going to explain how it works. Mr. Mitchell, I know that you may not have dealt with this
So
yet.
I called the DUI school this morning while y'all were talking, and I talked to Lannis. He did complete the school. He was referred to counseling. So DUI school consists of class and an evaluation. The evaluator makes a determination if you need additional treatment, substance abuse treatment. If they recommend that, then you have to go to a certified counselor that's certified by the DUI school. So according to her, they had not received any documentation from the provider that he went to of completing the substance abuse.
Which is after the class?
Yes, sir.
Okay.
So according to Lannis, may I ask Mr. Miller something? I'm sorry.
That's kind of to Mr. McDaniel. You can ask a question, and Mr. McDaniel will let us know if he wants to
Mr.
answer or not.
McDaniel, the DUI school, Miss Lannis thinks that, does Mr. Miller live here in Jackson County?
You live here in Jackson County?
Yeah.
Yes, he had some hearing difficulties, and so.
So what provider, did he go to a provider here, and who was that?
Did you go to someone for the classes for your alcohol treatment?
Yes, and there was an aftercare treatment as well that I went through in Mariana.
Who'd you go see?
I went to the Mariana Care Program.
Okay, so
Yeah, that was a 6 week program after the DOI class.
Okay.
So Ms. Landis did say, we have two providers here. We have CARE and we have Dr. Willie Spires. So it has happened before that an individual has completed the substance abuse and the provider failed to send the documentation back to the DUI school. I'm not saying that happened. I don't know if he completed it or not. But if he says he completed CARE, which is the after treatment, which is a certified program, they could have failed to provide the documentation to the DUI school. When the DUI school doesn't receive the documentation of completion of aftercare program, they notify the Department of Motor Vehicles and they suspend his driver's license. I don't know if he completed it or not. So,
And Judge, I don't know either, but I do know he had a license on him, and so he did have a license that were issued to him, so they had to suspend it at some time after that. He didn't, he's telling me that he had no idea they were suspended. And he's, like I said, it does give a little credence when you have a valid license when you get pulled over, or they're not valid, but they hadn't been taken from him.
Mr. Mitchell, she doesn't have a certificate that he completed CARE in addition to the certificate that you saw, does she?
I did not see the one for CARE. I was just asking her, who did he see there, and maybe possibly go by there and see if they got the certificate and a copy of that. And that.
I remember this happening once before, a couple of years ago. It wasn't CARE. It was the other provider that Mr. Goodson mentioned, and they essentially didn't notify the state that that person had completed the program. I'm going to err on the side of caution. And what I mean by that is I'm going to give you an ROR. You're going to get out of jail this morning. You'll deal with this at a later date. You've obviously got to get with CARE and get some documentation that you complete that program, get it to the state, and Mr. Mitchell will decide where it goes from there. But I'm not going to make you post a bond or anything. I'm going to tell you that according to the state of Florida, you don't have a driver's license right now. So don't be driving until this issue gets resolved. Ma'am, he can be picked up at the jail. By the time you get there, they'll be processing him out and he can be released. Mr. Mitchell, do you want him given a court date? It's a misdemeanor charge. Do you want him given a court date just in case, or do you want to give you time to look at it and then send him a notice?
Let's go ahead and set him on the August 25th date. And, we could tell his wife, go get that documentation from CARE, see if you can provide it to our office. And if I get it and I see that it's satisfied, I'll dismiss the charge, okay?
August 25th at 9 a.m. will be your court date.
Hold on.
Mr. McDaniel, you're saying something?
Yeah, let her know. I tried to explain it to him, but he's not quite grasping it, that she needs to go with him to DMV so they can get clarification of everything. I think all they need is that proof, but they need to see DMV because he didn't understand where he needs to go. And I tried to explain it to him over and over. So Department of Motor Vehicles, he needs to go there. Y'all need to talk to DMV and get those licenses fixed.
The old driver's license office out by the fairgrounds. Okay. So you're going to get out of jail this morning. Your wife's going to pick you up. I'm going to ask the jail to give you a notice for August 25th at 9 a.m. Ma'am, if the case is still pending, he has to be here August 25th at 9 a.m. unless Mr. Mitchell has dismissed the case. Okay. Mr. Miller, do you have any questions?
No, I don't.
Ma'am, do you have any questions?
No.
Go get that documentation at CARE, go to the DMV. That's the only two things right now that y'all can do right now.
Okay. All right. Thank you. Have a good day, sir. We have one more person, I think, that has friends or family. Actually, we have, is it pronounced Delana? Delana Lipford?
Your Honor, I do think it's spelled wrong, or I think her first name may be spelled incorrectly. I'm not certain.
Ms. Lipford, good morning. Ms. Lipford, can you spell your first name for me, please?
Yes, sir. It's going to be Delanea.
It is spelled wrong. Let's see if it's wrong on the complaint. No, the complaint is correct. Corporal, the jail paperwork is wrong. The first appearance sheet at least is incorrect. So Ms. Lipford, good morning. You're here because you've been accused of one count of domestic battery. Your co-worker, Kathy, is here. Your parents are here. And another young man that's came in since we started that's here on your behalf also. You're not the alleged victim, or are you? Okay, the alleged victim is also here. So Ms. Lipford, I looked at the complaint. There is probable cause in the complaint. And Ms. Lipford, it appears that you have no prior criminal history based upon what I've been provided from the jail. Is that accurate, Ms. Lipford?
Yes, sir. I was on probation for
for a hit and run, but I completed all of that, paid all my fines. But other than that, I've never been in no trouble. No, sir.
Yeah, that's not showing up on the criminal history, so she must not have been arrested for that.
I think I remember that one. I think I transferred it to a civil citation.
So was she on probation or not?
She was on probation?
Okay. All right. So that's not the kind of thing that's going to prevent me from giving you a conditional release. What I've got to address primarily is contact. And Mr. Scaff, Mr. Scaff, are you wanting to have contact with her? I need you to come on up then so I can get some testimony from you and see if this is where we're going to go from here. Just come on up to the microphone. Mr. Scaff, this is the alleged victim, Aaron Scaff. Mr. Scaff, let me get you to raise your right hand. Do you solemnly swear or from the testimony you're about to give in this case to be the truth, the whole truth, and nothing but truth, so help you God? You got a little shiner under your eye, I see there. Is that from this incident?
Oh, she's a swinger.
Okay, so here's the question. I read the complaint. She has no prior history other than the traffic charge that was just mentioned.
Yes.
Obviously, you have no serious injuries.
No, no.
My question for you is, do you want to have contact with her?
Yes, sir.
Okay,
Yes.
and you reside together as a family?
Yes, sir.
You have a child together is what the
Yes,
complaint says, and you want her to come back home?
Yes, sir.
Ms. Lifford, do you want to go back home?
Yes,
You can make that decision later.
yes,
I mean,
Okay. All right, so
yes.
what I'm going to do is I'm going to let you pick between a bond and a conditional release. I offer a conditional release a lot of times to individuals who have little or no prior criminal history, and they're not charged with usually some misdemeanors I don't offer conditional releases on, but when someone with a history like you, and if there's no serious injuries, I'm going to offer you a conditional release. Mr. Mitchell, I should have asked you first. Anything from the state? Any position on this from the state?
Your Honor, can I approach you right quick? I need to ask you.
I can't unless Mr. McDaniel can hear it.
I don't know whether or not to mention it or not involving Mr. Scalf right quick, but
I can't talk and without Mr. McDaniel's permission.
well, hold on.
I don't
John,
mind.
did you get
I
that
don't mind
message?
at all.
Okay,
Oh,
all right. I sent him
I
a
don't mind.
message earlier. Hold on, let him see if he can read that message.
Stand out if you need me to or something.
I have no idea.
No, I just wanted to mention that, Mr. Scalf was on probation in 24141MM involving Miss Litford, where she was the victim. I didn't know if you need to know that at all, but
What's the time frame on that?
he was put on probation April of last year, and I think he just completed it this year, April of this year.
So he successfully completed that program?
Yes, he has successfully completed this. So this happened a couple months after that incident.
Okay.
But
And in this case, there was
Yeah,
allegedly
I know.
alcohol involved on both parts, is what the complaint alleges. So I'm gonna let you pick between the bond and the conditional release, Ms. Lifford. You will have a condition, no alcohol, no possession or consumption of alcohol while the case is pending. If you would like to post the bond is $2,500, ma'am. If you'd like to set up the conditional release, I'm glad to offer you a conditional release. I am going to have a condition of no violent contact with Mr. Scaff. So if you choose to reside there and y'all choose to live together, that's up to y'all. But there is a condition, no violent contact. What that means is if there are accusations of violent contact by you against him or anyone else, then ma'am, that could violate the terms of your conditional release. Do you have any questions about your choice between the bond and the release, Ms. Lifford?
No, sir.
Which one do you want to choose, ma'am? The bond or the conditional release?
Can I ask Mr. Scaff one question real quick, Your Honor?
Sure.
Mr. Scaff.
Yes, sir.
Your wife is basically telling me that you were holding her down and she didn't want to be held down and that's why she was punching you. Is that accurate?
Sir.
I mean, if you just say yes or no.
She was swinging pretty good on me, sir, and yes, I held her down for that reason, but I didn't.
Okay, she said she was walking away from you, trying to get away from you. You kept coming up to her and then trying to. Okay. So. Your Honor,
So what's your choice on the bond or conditional release, ma'am?
Cash bond.
I don't know if I can afford it.
Okay,
There's
conditional
some-
release, Your Honor. We'll take conditional release.
Just, can whether things work out or not, I just wish she could come home, get her stuff, whatever she wants to do.
Okay.
you know.
Well, there's a condition, no violent contact. I'm gonna grant you the conditional release. What that means to your parents, you can have a seat back if you want to, Mr. Scale, so your parents can hear me. So she will be brought to the courthouse. She'll be processed out, let her get dressed in her regular clothes. She'll be brought to the courthouse because that's where the conditional release office is at. When she gets to the conditional release office, they have to go over the release with her, explain it to her, give her a chance to ask any questions, give her the rules in writing of conditional release, and then she'll be free to go. That's probably gonna be 30 to 45 minutes from now. So I need either Mr. Scaff or one of you to pick her up. Your dad's gonna pick you up just to try to keep the peace for the time being, and then you'll decide whether you want to go back there or not. And that'll
Yes,
be 30 to 45 minutes from now. She should be at the jail. Okay.
Yes.
Do you have any questions, Ms. Litford?
No, Your Honor.
Mr. Litford, did you used to work at McDonald's, Highway 71?
No,
So
sir.
when I was about 17, Mr. Litford and I worked at McDonald's on Highway. I hadn't seen him in years, but we pretty much ran that whole end of the county as far as fast food service. I think that may have been the only thing they had out there back then. Yeah. So I hadn't seen your dad in years and years. It's good to see you, Mr. Litford. But Ms. Litford, someone will be here to pick you up at the courthouse. You don't have to worry about transportation. You just need to figure out if you want to go back there or if you want to stay with your family for a while or whatever you decide to do. Just no violent contact. Lastly, when you get here, they're going to give you a notice for your court date. And if the case is still pending, if Mr. Mitchell's office, if they decide to dismiss it, that's their call. But if it's still pending, your court date will be August 25th at 9 a.m. They'll give you that notice when you get here. Any questions,
Yes,
ma'am?
sir. No, Your Honor.
Ms. Williams? D.
Hang on, I'll pull it up in our system.
How do you spell your first name again, Ms. Ledford?
Delanea.
So the cover sheet from the jail is correct, Sergeant. It's just the first appearance sheet is wrong. They don't match. All right. I wish you the best, ma'am. She'll be downstairs in 30 to 45 minutes. Okay. Thank y'all.
Yes, sir.
All right, let's move along in an effort to give you the 9 to 11% more Judge Boyd that you all have requested. Let's say good morning to Judge Boyd. She's got Hollywood Squares going on. She doesn't do that often anymore.
Odyssey is just taking a while. Just give me a moment. All right. On Justin Granado, counsel, has an offer been tendered?
No, Your Honor, I've been dealing with Judge Garahan on this matter. This is a TSA case, and he was going to check with his supervisor, and I have tried to contact him, and I haven't gotten a response yet.
All right. Mr. Garahan is here.
Judge, that's accurate.
Good morning.
Good morning. He did send me a couple emails, and if I could, well, I mean, if he can call me, I can talk to him.
All right, Mr. Seeloff, if you'll call Mr. Garahan, he'll speak with you. What I can tell you is they're in the middle of the jury trial, so that's probably
Sure.
why he's been able to reach back with you.
Well,
But
I understand.
if you give him a phone call, he'll speak with you.
If he could give me a good phone number, I will call him and tell, and I ask what time should I call since he's in trial.
He can call this morning, Judge, but I don't know if you could take him in a breakout room.
Yeah, I'm gonna send you in a breakout room, counsel, and he'll speak with you today.
Thank you very much, Judge. And my client is present, Justin Granado.
Yes.
What do I do?
And Mr. Seeloff, you go to breakout room number 1. Mr. Granado, you just remain on the screen.
Okay, thank you.
All right.
Thank you, Judge.
Can there's any way to give him myself?
Yeah, I'll give you his cell.
Okay, that's great.
They're here, enjoy, and then Michelle Prince.
Yes.
Okay, Jason, one of those numbers are correct. Thank you. All right, Oberlinder. Cindy, are you ready? Court is calling 2024 CR 012530, State versus Cassandra Oberlinder. Could I have the state announced?
Dustin Whitlock for the state of Texas, Your Honor.
All right. And for the defense?
Roberto Ambrosino for the defense.
And you're Miss Oberlinder, is that correct?
Yes, ma'am.
All right, so you entered a plea. We are just here today for sentencing. Is that correct, counsel?
Yes, Your Honor.
Any objection to the defendant appearing by Zoom, state?
None from the state.
All right, state, you may be excused. And Miss Oberlinder, do you have any objection to appearing by Zoom?
No, ma'am.
All right, Miss Oberlinder, are you employed?
Yes, ma'am.
And what do you do?
I cook at Chili's.
Oh, okay. And where you are, do they still have the Southwestern egg rolls?
Yes.
All right.
They give you 4 now instead of 3.
All right. So do they make them the same everywhere, or are they just different depending on what state you're in?
Wherever I'm cooking, they're the best. No, I'm kidding. I think it's the same throughout each state. I'm not sure about the quantity if it's the same, but yeah, everybody's making egg rolls.
And do you have any children?
3 boys.
What are their ages?
16, 10, and 2.
Right. And any prior drug use in the past?
Yes, in the past, yes, ma'am.
And what would that be?
Marijuana.
All right. All right, this is what the court will do. And I'm so sorry, last question. What county are you in Colorado?
El Paso County.
All right, this is what the court is going to do. The court is going to sentence you to 2 years deferred adjudication. There's to be regular reporting by Zoom or in person, regular random UAs, proof of employment within 30 days. There's to be no employment as a home health care provider or with minors. There's to be no contact with Gregoria, Gregoria Ramos, plus restitution, if any, to Gregoria Ramos. Norma, I need a 30-day reset for a restitution hearing on this. All right, your restitution hearing will be August 21st. You can appear by Zoom. There's to be 100 hours of community service restitution. I'm going to order parenting classes. Once that's completed, your community service hours will be deemed satisfied. Have you ever been diagnosed with any type of mental illness in the past or been on any type of medication for mental health?
I am currently taking mental health medication, and I am diagnosed with bipolar, generalized anxiety, PTSD, and I think that's it.
All right. And I don't know if they have field visits there or not, but if they do, if they do, Ms. Abrams, I'm going to want field visits 1 time per month until further notice.
I'm sorry.
Yes.
You said no employment with minors for the 2 years as well?
Yes.
Oh, okay.
No, that
Okay.
means that you can't be a babysitter. You can't
Or a
work
teacher.
at a daycare.
Yeah.
You can't do any of that. Now, if for some reason somebody is hiring you as a teacher, then your attorney can file a motion. I will hear it and I'll make a decision on whether or not I deem it's appropriate. But what I can tell you is when people are getting jobs with vulnerable people, number one, before I even consider allowing it, I want a letter from that employer stating that they're aware that you're on probation and what you're on probation for.
Okay, okay.
There's to be mental health treatment.
On
And you're
top of, okay, sorry.
And you'll need to sign a release so that the probation officer there can obtain your mental health records and make sure that you're stable on your medication. And there's to be a transfer to El Paso County, Colorado. Probation, is there anything else? Is there anything else that you need from the court in order to be successful on this probation?
No, not less probation. No, I'm kidding. Oh, no, I think everything, I can meet all those standards. I can definitely do that.
Right. Did you review the
100
document?
hours community service.
Yes, and probation will explain that to you. So I'm ordering that you take parenting classes. So once you complete the parenting classes, the community service hours will be deemed satisfied. So,
Oh,
yes, so you'll complete parenting, and once you've done that, then your community service hours will be deemed satisfied.
okay.
I'm
Awesome.
a firm believer that sometimes community service is helping yourself, and when you help yourself, you help the community.
Yes.
So I want to make sure you have the tools you need to be a good parent to your children. All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
I think I do. Yes, ma'am.
All right, so your attorney didn't file any pretrial motions that the court ruled upon. So by entering this plea, you're saying you're not going to appeal this because I followed the agreement that you reached with the state. Do you understand?
Yes, ma'am.
So I'm just letting you know you do not have the right to appeal.
Okay. Okay. Thank you.
All right, so your next court date is going to be August 21st, and it's to make sure that if there is some restitution, that you'll know the amount. If the state determines that there is no restitution, or the court doesn't receive a letter requesting restitution, then there will be no restitution that is due. But you can appear by Zoom. Do you understand?
Yes, ma'am.
All right, I'm going to send you to breakout room number 2 with your attorney and with probation, and probation will go over conditions with you.
Okay. Thank
All right,
you so
thank
much.
you. Have a
Have
great
a good
day.
day. You too.
Who is here? Michelle Pettis. And where's your client?
She is not here, Your Honor. I have attempted to call her and text her and every form of communication I can think of, as well as contacting her bondsman. I have lost communication with her. She just hasn't.
Just 1 second. Deputy Laura, could you make an announcement for Michelle Pettis in the hallway? Supposedly she already has a warrant.
Yes, I believe the bondsman issued an affidavit of surety. I could be
Okay.
incorrect about that, but I believe that is what happened.
Let
I
me
don't think
see.
they've been able to get in contact with her either.
Mhm. All right, the court is calling 2025 CR 007165, State versus Michelle Pettis. Can I have a parties announced for the record?
Duffy Pitlock for the state of Texas, Your Honor.
And Andrea Matos for the defense.
All right, this hearing was scheduled at 9 a.m. It is now 9:21 a.m. Deputy Laura, did you make an announcement?
Yes, Your Honor, I did. She got out there.
All right, and for the record, the court called the docket at 9 a.m. and the defendant was not present. It's the court's understanding that there's been an affidavit to surrender surety on this case that has previously been signed. Defense, have you had any contact with your client?
I have not had contact with my client in over a month and a half. I've attempted to call and text the defendant multiple times to notify her of the hearing and of my motion to withdraw.
All right. And are you retained?
Yes, Your Honor.
All right, this is what the court will do if there's no objection for the state. I'll issue a judge's warrant, remand her without bond, and then once she's in custody, I'll hear your motion to withdraw.
The state has no objection.
Right.
No objection, Your Honor.
All right. Thank you so much.
All right,
Your
thank you.
excuse.
Thank you, Your Honor.
Okay, folks, real quick, I'd like to make you aware of something new that will be happening today at 8 p.m. Eastern, 5 p.m. Pacific today. We will be adding a new show to the channel. It is called Sidebar, and we will have an hour-long discussion about something having to do with the court, and this is the idea of channel members. So I will be joined by Ashley and Bailey and Michael, and we will have a panel discussion for an hour about something. Today we're going to talk about a situation where shortly after a murder verdict, there was a fight just outside the courtroom and a bunch of people held in contempt. So we're going to discuss that whole situation. So I invite you to join us again. It'll be at 8 p.m. Eastern tonight, 5 p.m. Pacific. The plan is to do it on Tuesdays and Thursdays. But today will be episode number 1. So please join us. If you're not already subscribed with the notification bell on, hit that notification bell so that you're alerted when we do go live. Let's go back to Judge Boyd.
To take care of myself. I'm a mother and a father, and I have never done anything. They just get me inside my garage, and three men run over me. And you see the way I lose weight. I haven't eaten no food, and I'm dying here. None of my family here. I'm actually a lawyer. They cannot recite me. Just release me and let me go home. I have 3 kids, and my kids went CBS, and I don't have nobody help me. I don't have nobody be there because they took my phone. And I have 7 lawyers. 7 lawyers represent me. They're not here. My family is not here. My kids is CBS. I never done anything. I was in my garage, 3 men ran on me. By the way, I have the video. They never record me. I'm not supposed to be here.
Okay.
So I need to go home, please. That's what I requested.
All right. Thank you for letting me know that. All right, Ms. Ferguson.
That's what I requested. Because my kids almost like 7 months, CBS, and I have to go jail, another jail. This is wrongful. I'm not supposed to be here.
All right, so this is what we'll do. We'll have your civil lawyer. We'll make sure that the civil lawyer is here as well for our next setting. Ms. Ferguson, Deputy Laura, she can go back. And Ms. Ferguson, I need a phantom setting for September because they're probably going to transfer her to an inpatient facility. Yes. 29th or 30th.
Of September, correct?
Yes.
I can do either one of those dates. That's the 29th.
All right, thank you.
Thank you, Your Honor.
Judge?
Thank you. Yes, I see you. Just give me a moment, Mr. Seeloff.
Oh, okay.
Yes. All right, on Granada.
Thank you.
Yes, Your Honor. I just talked to Judge Garahan, and he informed me he is going to agree to PTD. And so as soon as I get the application, I'll send it to my client.
Ms. Ferguson, I need a PTD date on Granada, please. All right, so we're going to bring you back on August 21st. That'll be by Zoom, Mr. Granada. By that time, the application should have been filled out by you and your attorney, and it should have been transferred to the state. All right, is there anything else?
May we be excused, Your Honor, and I'll call my client.
Yes, you may be excused. Thank you.
Thank you. You may leave, Mr. Granado. Thank you, Judge.
You're welcome. Richard Mermea.
Hello, Judge. How are you?
Hello, how are you doing?
Doing well, ma'am.
Oh, that is good. And thank you for dressing appropriately for court. I appreciate that.
Yes, ma'am. I was, this is the only color shirt I have, so I'll put it on today.
No, you're dressed appropriately. I appreciate that.
Yes, ma'am. Thank you.
All right, so how things are going with the mental health court?
So he was, I had did the assessment last week, and then they had me come back this week to finish it.
Okay.
So, they also told me, I think they said that they transitioned to take over mental health court.
Yes.
So, she said because you recommended it, it's more than likely that you should, be able to accept it. I'm not trying to push that, but if it's possible, then.
Right. So what was my understanding, there's a staffing, I think, on Friday. So we should know something by then. And Mr. Porter, if you want to submit a letter or be at that staffing, just let the court know.
Okay, thank you.
All right, so what we're gonna do, Ms. Ferguson? Yes. Recall this. Let's recall this for the week of August 18th. And then, Mr. Porter will know well before then whether or not he's accepted into the program. Is August 18th good for you?
Yes.
All right, so we'll bring you back on August 18th, okay?
That's it?
Yes, well, once you sign the reset form.
Okay, man, my part. Go back.
Who is here on Justin Lee Heather? Good morning.
He's not on today's docket, but I came by to ask. He has been going through all the screenings for mental health PTD. He had a psych evaluation yesterday, and then they're having a home visit on August 1st, which is the day after his scheduled court date. He has severe anxiety, and I'm just wondering if I can maybe reset the court date a few weeks so that he doesn't have to come here and then have the home visit the next day.
Well, he can appear by Zoom.
Okay.
Yeah.
Okay, we can do that.
Yeah, just have him appear by Zoom.
Okay, we'll do that.
And I'll make a notation.
Thank you, Judge. I appreciate it.
Yes.
Thank you.
Oscar Lopez Jr. Good morning. Where's he?
He's right. Yes.
Oh,
Good morning.
morning. All right, so where are we on discovery?
Judge, this is, for some reason, it shows on the trial docket, this is our first appearance, first setting.
Yeah.
We have discovery.
Everything says Odyssey that it's trial.
Okay.
So where are we on discovery?
The state is having to do a disc for me. There's some very large files I have not received yet. Also, there's two things I just saw in the file that haven't been disclosed to me. So we're in the beginning stages of discovery. I did file a motion on that. So I need a reset for them to get me those files. And they're also going to get me an offer before our next.
All right, Ms. Ferguson. Set this for discovery in 45 days, please. And state you'll need to be prepared to tender an offer at that time.
Yes, in the 45 days.
Yes.
Yes, Judge.
All right, thank you.
All right, thank you, Judge.
Okay, so let's go back to Judge McNally. In just a moment, a gentleman is going to walk up. You know, Judge Boyd always congratulates people for dressing appropriately, and then there will be this guy. So hang tight. In just a moment, you'll see what I'm talking about.
Mercure.
Yep.
Yeah, you have to have a seat right there, sir. Thank you.
What's wrong?
He needs to tell me whether or not there was an accident. There was an accident, minor injuries, no injuries, minor damage, whatever it is. Michael Jacob Collins, 25R514-159. Come on up to the podium, there, your name?
Michael Jacob Collins.
All right. Okay, you're gonna plead to impeding, right?
Yes,
Who's Latasha Collins?
that's my mother.
Is she here?
No, I ended up telling her to stay home because I was just running here for football practice.
All right, so you gotta, so we need you to, you gonna be able to pay these fines today?
I already paid.
Well, that's posted by her.
Yeah,
It's in her name. She gonna allow you to apply the bond?
yeah,
She is?
yeah.
Okay, so you're gonna have to talk to them down the hall, to the charge impeding, responsible or not responsible.
Okay,
Do you plead responsible or not responsible?
I plead responsible.
Default judgment set aside, plea is accepted to impeding. 175 is your total. Go talk to them down the hall and they'll tell you how to go about that, okay?
Thank you.
Good luck to you. Good luck with your football, eh? Cray.
So Michael said, Judge Dad, just let that go. Judge Dad lets that stuff go pretty consistently, and I don't understand it because he's so hard on so many things, but he lets that go. But I wanted to show that to you guys because it just really caught my attention. He's fresh off the basketball court. Judge Stevens would have an aneurysm, says Michael. Isn't that the truth? Speaking of which, let's go to Judge Stevens.
We now call cause number 23 CR 669, the state of Texas versus Riley Lee Holmes. Who is present with his attorney, Brittany.
Yes.
Holmes. Y'all aren't related?
No.
Does the defendant waive a formal reading of the indictment and the arraignment here? Can we proceed in summary?
Yes, sure.
In summary, this indictment alleges that on or about March 17th, 2023 in Jefferson County, Texas, you committed the third-degree felony of evading arrest or detention with a motor vehicle. Do you understand what you were charged with in this indictment?
Yes, Your Honor.
Right. It's like there is an agreement that you would be pleading guilty to the lesser included offense of eluding.
It's gonna be the transportation code.
What section is that?
545.421.
Five.
45.421.
Huh.
Mhm.
You sure? Because it's not in this.
Transportation.
In the transportation goes, it goes 524.051 to 550. Goes from 524 to
Just
550.
changed it from what I was looking at. 421. Yeah, I'm still going. 47, 420. Gotta keep going, because it's right there. Fleeing or attempting to elude a peace officer, 545.421.
Yeah, it's just,
Yes, sir.
it's not in this. It's
Here,
not in the book.
here's the code section, Judge, if you want to look at it.
No, that wasn't included. According to section 545.421 of the Texas Transportation Code, a person commits an offense if the person operates a motor vehicle and willfully fails or refuses to bring the vehicle to a stop, or flees or attempts to elude a pursuing police vehicle when given a visual or audible signal to bring the vehicle to a stop. Except as provided by subsection D, which is that it would be a Class A misdemeanor if the person is recklessly engaging in conduct that places another in imminent danger of serious bodily injury. It is otherwise a Class B misdemeanor.
Yes, sir.
Right?
Yes, sir. That's correct, Judge.
Which means you face no less than 180 days.
Up to 100.
Up to 180 days in the county jail and or a fine not to exceed $2,000.
Yes.
Do you understand what you are charged with and the punishment range that is? This says a fine not to exceed 4,000, isn't it? 2,000?
2,000, Your Honor.
Yes. Okay.
Are you up for?
An agreement has been reached where you would be pleading guilty, sentenced to 30 days county jail. Is that your understanding of the agreement?
Yes.
If I follow this, you have no right of appeal of your case. Do you understand?
Yes.
You know, this pad is odd.
I know, but this other one's acting out, Judge.
Okay.
October 1st, we're supposed to be able to order our new tablets. New budget year. But hang on till then.
So again, how do you plead to this, guilty or not guilty?
Guilty.
You're pleading guilty voluntarily and because you are guilty.
Yes, sir.
I show you what's marked as State's Exhibit 1. And you need to sign at the bottom.
Yes.
I hope it'll work. That stylus is not friendly with the pad.
That's your signatures. There, in there.
Did you sign that document?
Yes.
Understand it, discuss it with your attorney, or the contents true and correct?
Yes, sir.
State's Exhibit 1 tendered into
No
evidence
objection.
without objection admitted. This states you are mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You were guilty of the crime charged in any lesser included offenses. You were giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. You were totally satisfied with the representation provided by your lawyer. All true, so help you God.
Yes, sir.
State's Exhibit 1, part of the record for all purposes, is a pre-sentence report waived.
Yes, sir.
I'm going to follow this agreement. I have nothing further and find you are pleading guilty to this lesser included Class B misdemeanor of eluding law enforcement voluntarily, knowingly, intelligently. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt. I now find you guilty beyond a reasonable doubt of this Class B misdemeanor. I'm following this agreement. You are hereby sentenced to confinement to the county jail for 30 days. You will be given credit, of course, for time you have served. You understand what has happened today?
Yes, sir.
Have you served more than 30 days?
No.
Yeah, no.
5 days. He only has 5 days.
Okay, well, he's got to be ordered to report.
Yes, sir. He's gonna go to
When?
custody.
Immediately? When, we got to figure that out.
Mhm.
You gonna go into?
Get it done.
Today my son's birthday, but
Can you go tomorrow, Friday,
yeah,
at 6 o'clock? Can he report Friday at
Yes.
6 o'clock?
But you need to hang around till they take that monitor.
that's fine.
Also, don't fail to do that. They're going to be expecting. If you
Mhm.
fail, then you get into all kinds of more trouble.
I'll be there.
And then I can undo this deal. And then you're starting from scratch, because she's fashioned a pretty good deal for you.
Thank you.
Yes, sir.
Thank you.
Okay.
There's someone here to take the monitor
Great.
from you.
Okay, thank you.
Okay, wait.
And then I can.
No, you can come on back here. They're here. Thank you. So. Hold on, 31.
Stephen Allen. Here's this. Thank you.
Yeah. You want to do it all?
We're all very strict probation with restitution.
22-40573 is now called the State of Texas versus Stephen Dustin Allen, which is you. Present with Mr. Kimber, your attorney and the state's attorney. Does the defendant waive a formal reading of the indictment and the arraignment here? Can we proceed in summary?
So waiving your name.
In summary, this indictment alleges that on or about June 29th, 2022 in Jefferson County, Texas, you committed the third-degree felony of unlawful possession of metal or body armor by being a convicted felon. As of 2006, you convicted in this court of the felony of fraud. Do you understand what you're charged with?
Yes, sir.
If convicted, you face a term of not more than 10 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand?
Yes, sir.
An agreement's been reached where you would be pleading guilty sentenced to 10 years in prison, that would be suspended. You would be placed on regular probation for 10 years, fined $500. Is that your understanding of the plan? If I follow this agreement, sir, you have no right of appeal of your case. Do you understand?
Yes, sir.
How do you plead to this third-degree felony? Guilty or not guilty? Or you? Both?
The timing was funny.
I understand, but I thought it was ironic both you and your attorney pleaded guilty.
I can possess money.
Which is
If he wants to take the case.
No,
something that's overdue, long overdue for him.
I can legally possess money.
Are you pleading guilty, Mr. Allen, voluntarily and because you are guilty?
Yes, sir.
Oh, I'm going to show you, sir, what's marked as State's Exhibit 1. Did you sign that document voluntarily? Understand it? Discuss it with your attorney, or the contents true and correct?
Yes, sir.
State's Exhibit 1 is tendered into evidence.
Without objection.
Without objection admitted. Among other things, the state you were mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You got it. You are guilty of the crime charged in any lesser included offenses. You giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. You were totally satisfied with the representation provided by your lawyer. Thank you so much. All of this is true, state. So help you God.
Sir.
State's Exhibit 1 is part of the record without objection and admitted. Anything further? I'm going to follow this agreement, if nothing further, and find you have pleaded guilty, Mr. Allen, voluntarily. You're mentally competent to do so. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt. I now find you guilty beyond a reasonable doubt of this third-degree felony of unlawful possession of body armor. I am following this agreement. You are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 10 years. That confinement is suspended. You were placed on regular probation for 10 years. There will be terms and conditions of probation, which are normal and customary for this type of offense. Also, there's a fine of $500 attached to this. Please do well. We can get it shortened in a third. Okay. Anything else? That is all. Thank you. Please see the probation officer.
Got to do that I-1 earnest class.
All right, let's switch it up a little bit. We're going to go to Bay County, Florida. This is Judge Joe Grammer, who I have not seen on this channel before. We haven't featured him. He's doing felony proceedings, and right away, the one attorney at the lectern there looks like the guy from Home Alone. So let's see what this is all about.
And that's the current status as I know it right now, is that we're trying to coordinate between 7 lawyers.
Some of the depositions have been set for August, so we'd like the September trial, or not trial date, but pre-trial.
Is this the robbery case that has a bunch of people in it? And what's your name, ma'am?
Kayla.
I just can't find you on the list here. What's your last name?
Gonzalez?
Velos Gonzalez.
Gonzalez. You understand what the lawyers are saying, ma'am? I see you. They want to set you for another date in September.
Yes, sir.
Okay. That's what you want to do too, Stan?
Yes, sir. That's
Okay.
that under the current
Y'all are
circumstances.
going to be able to get the depots taken maybe before then?
Some of them are scheduled in August. I think there's going to be multiple rounds in this case.
Okay. All right, good deal. I don't know that date, so one of our clerks will tell you what it is. And
September
18th. All right, we'll move you to that date, ma'am. Do you have any questions?
No, sir.
All right, take care. Yes.
Okay. Go ahead, sit down. Go sit down.
Good morning, Mr. Ricardo.
Good morning, Your Honor.
Would you call the Spanish speaker up, please?
Yes,
He's
Your Honor.
talking to his attorney right now.
Mario Ramirez
That's not him.
Garcia, venga adelante.
Nope. Okay. What's this guy's name right here? Okay, he's okay speaking English. All right, Jordani, we'll get a Spanish speaker out here pretty quickly. Yes, Matt? Okay, all right, let's bring somebody else up. Okay, go ahead, Lee. Oh, I see the dates right here. Thank you.
Your Honor, this is Cesar Danielle Cova Espinoza, cases 25-389 CF and 25-1192 CF. He would like to change his plea and enter a no contest plea to an adjudication withheld on amended to trespass, petty theft, resisting without violence, criminal mischief over 1,000, and the state is dismissing the DUI second, the DV bat, and the refusal. He's agreeing to 24 months probation, court costs, fines, and community service. Restitution, total amount of $254.19. Credit for time served, 100 hours of public service, $20 monthly cost of supervision, drug offender probation. Defendant stipulates to the facts in the probable cause affidavit as a prima facie basis for the offense. Department of Motor Vehicles may apply additional penalties. DNA sample, forfeit seized items. Defendant agrees to the imposition of a minimum cost of prosecution. Mental health evaluation and counseling as recommended. No contact at all with the victim or co-defendants. Do you understand that?
Yes.
And I believe that that takes her case also.
Okay.
Hi, Judge. Yes, I'm counsel of record on 25-389, and this is a global PR.
Okay.
Which is better than what this was an adjudication.
What cost form do we need for him?
C for private. I think just one since they're on one form. Is that right?
Sir, if you agree to that plea, if you'll sign that
There's one
plea form.
with case numbers on it.
Yeah, that's time served.
Yes. He doesn't do the double? Okay, so it's, Mr. Mayor, six. Yeah, mine were misdemeanors. I like that pen. Let me take that. Yeah, you need to sign this one here.
Your education. God, if you can't remember it now.
All right, would you state your name on the record, please, sir? Sir, would you state your name, please, for me?
Cesar D. Espinoza Cova.
Okay, and you're represented by two counsel today, two esteemed lawyers, right?
Yes, sir.
And are you satisfied with the services of Ms. Scott and of Ms. Anderson?
Yes, sir.
Are you under the influence of any drugs, medications, or alcohol?
Not at all.
Have you been forced, threatened, or coerced to enter a plea?
No, sir.
Has anyone promised you anything other than what's been made part of this plea agreement?
No, sir.
Is there anything at all about you today that would keep you from understanding what's going on?
Not at all.
All right, so on the one case that you're getting the 24 months probation, do you understand if you violate your probation, you could get up to 5 years in prison?
Yes, sir. I'm aware.
Okay. Is there any known evidence or any known DNA that could affect the outcome in this case or that we need to take into consideration? Sir, you're getting time served on the misdemeanors, if I understood. Is that right? So you're going to be adjudicated guilty on the misdemeanors if you get time served, but withheld on the felony. Do you understand that?
Well, I thought he was a withhold across the board, but
Well, you can't get withheld on it if you're getting time served.
Whenever it's checked on that box.
I mean, if you just want to make it a fine and something to happen after, if he doesn't do it.
Is there any way to do? Because he doesn't have any prior convictions.
Well, sure, we can just make it a fine on those misdemeanors and not say time served.
Great. Thank you.
Okay.
Thank you.
So, sir, that's a little bit different than what I said. So you will not be adjudicated guilty on the misdemeanors. We're just going to give you a fine on those cases.
Yes, sir. Thank
Okay. All right. And we'll give you some time to pay that. Let's see if I can figure out the money in here. All right, sir, I'm going to find your pleas freely and voluntarily made with knowledge of the consequences. There's a factual basis based upon the complaints. Withhold adjudication on all counts. As to each misdemeanor, your fine is going to be included in the felony fines. That total fines and cost and fees are $1,253. You're sentenced to 24 months on probation with the Department of Corrections in the felony case. Restitution's assessed in the amount of $254.19. Court costs and fines, we've already said that. $20 of that goes to the Crime Stoppers Fund. You'll perform 100 hours of public service work through the Bay County Work Program or at the direction of your probation officer, at least 8 hours a month. Cost of supervision's $20 a month. This will be drug offender probation that includes random urinalysis at your own expense. You'll have to comply with all drug offender conditions. The DMV may apply additional penalties. They usually don't when there's a withhold of adjudication, but we don't control them, so good luck. Forfeit any seized contraband items, submit to a DNA sample. You'll submit to mental health evaluation and counseling as recommended. Don't have any contact with any victims or co-defendants. Do you have any questions about any of that, sir?
Not at all.
Great. All right, good luck to you. You should be released as soon as they can get you out of there.
Thank you.
All right, report to your probation. How soon do we usually tell them to report to probation?
As soon as he gets out in time, he'll need to report today.
Okay, if you don't get out in time, go tomorrow. Okay, good deal. You understand that, sir?
Yes, sir.
All right, take care.
Thank you.
Thank you, Your Honor. Nice
You're
to meet you.
welcome. Good to see you, Lisa. Stan, is your
Okay, guys, so as mentioned a little while ago, we have a new show coming on tonight called Sidebar, where this is a member idea, a channel member idea, and we're going to discuss cases. One of the things that we're discussing, the big thing we're discussing tonight, was in front of Judge Stevens a few days ago, where some people after a murder verdict were fighting, and he brought them in on contempt. Well, two of the three are in front of him right now. So we're going to go to that and see where this happens. If nothing else, it gives you a reason to tune in later today to get the prequel to this. I don't know if this is going to be a resolution or not, but let's just see.
Actually, the damages were far less than I thought they were going to be. 8,000. I thought it was going to be 2,000 or 3,000. But still, you don't pay a dime. Somebody wants to pay any money for, it is up to being 500 and something divided 3 ways. It's the way you're going to do it. Come on up. Just go on up, sir.
That would be like the presumption, you get a jury.
All right, we call, you're staring out in jail. You have to speak up, sir.
Yes.
Thank you. And Charles Nicholas Senior.
Yes.
And Charles Nicholas Jr.
Yes, sir.
Oh. On July 18th, which is 6 days ago, last Friday, this court was in court session on the case of Stephen Angel as a defendant in a murder case, and the jury had returned a verdict finding the defendant guilty of murder. It was about lunchtime. We broke for lunch, and I ordered the jury to return back and the parties to return back after lunch to begin the punishment phase of the trial. While we were in that phase, Mr. Grove and the parties were exiting the courtroom. Mr. Grove, David Grove, one of our public defenders, was proceeding immediately into a hearing that we were conducting on a plea. And what was the case, David? Do you remember the defendant's name?
No, sir.
Okay, because you do a lot of them. Here, everybody gets one of these. You got one of these. You give this to Mr. Andrew. Thank you. And as the parties were exiting, Mr. Grove was beginning to get this plea underway, and then we were breaking for lunch and we were going to return back. The jury was just exiting here at the doorway. The court heard voices, loud voices. The slamming on, there was a slamming and bumping up against the door. The bailiffs rushed out to take care of what was obviously a disturbance going on at the courthouse door. And the court had to terminate in the middle of the hearing and postpone that for a later time as we were resolving what the disturbance was. So the court walked out and then saw the three individuals being arrested. And these were family members of the Stephen Angel case matter, people who were involved, victim, defendant, related, three people related to the parties. The court, in just a matter of minutes, actually received a copy of the video of the proceeding. There's a camera right over our doorway. And I looked at that, and it was plain to see what had happened, where three people, the parties involved in this matter had gotten into a confrontation, and shoving and the throwing of fists were part of a fight that was going on. Involved was Charles David Nicholas Sr., Charles David Nicholas Jr., and Stephen Angel. Unfortunately, these are Mr. Angel is related to the defendant, and then the Nicholases are related to the deceased in the murder case involving Stephen Angel that the court was in the middle of and had just received a verdict. So the court brought the individuals in because the court was in a multitude of important matters at the time. We could not fully conduct a hearing on that matter, but the court reviewed and is following the Court of Criminal Appeals decision in 1987, Ex parte Daniels of the Texas Court of Criminal Appeals, which is quite similar in issues and facts to the issues in this matter of contempt, as the court ordered them to be presented to immediately come before the court, and the court orally charged them, the three individuals, with contempt. And the issue became, is it direct contempt or constructive contempt? That is, direct contempt or indirect contempt. Direct contempt occurs when it occurs in the presence of the court. Indirect is a matter that occurs outside the presence of the court, but in each case, disruptive behavior, committing a crime, failing to follow a court order, all of those are part of the equation that the court has at its disposal in dealing with matters to ensure that the court's business is conducted in a civilized, peaceful, lawful fashion. The big question, the big issue here on this case is direct contempt versus indirect contempt. Direct contempt involves behavior which occurs in the presence of the court. The court was sitting where it is now, on this bench, in this chair, and the people in the court had been recessed on the murder case on Mr. Angel for lunch, and we were return afterwards to pick up the punishment phase. And at the doorway, the court, as people were leaving, the court then was, as Mr. Grove was beginning his plea with his client, the court heard loud noises, shouting, banging on the door. The bailiffs in my court exited quickly and moved toward the noise and exited. And this hearing had to be stopped. So it interrupted the court's hearing that was being held with Mr. Grove and his client. But yet, the court went outside and saw these three individuals being detained by law enforcement. The court saw some jurors watching from a vantage point not far. I noticed some of the jurors were watching and from that murder case, and then they left. There was damage to the chairs outside the courtroom, and then the court brought the three individuals here today, Mr. Nicholas, and Mr. Angel, and then spoke to them about their actions, which this court deemed to be disruptive and in contempt. The court had also, within just a few minutes, 5-10 minutes of the event, received a copy of the camera recording of the scuffle, and this court picks up from when the parties were leaving this courtroom at the doorway, and then this court saw, even though there's no audio to it, the court saw the confrontation begin, then turned shoving and punch throwing. And then authorities intervened quickly. But at the conclusion of all of this, what had happened is this court's business was disrupted. The scuffle is occurring at the doorway of the courtroom. Jurors of this case were in the vicinity and could see what was going on. This is bad in many different ways, and this isn't the way the rules of procedure and the rules of handling matters in this courthouse are supposed to be handled. So, to preserve the Court of Criminal Appeals, the highest court in criminal cases for Texas, has stated that to preserve order in a courtroom for the proper conduct of business, the court must act instantly to suppress disturbances or violence or physical obstructions or disrespect to the court when occurring in open court. And there is no need of evidence or assistance of counsel before this court can exercise its enforcement and punish those who are disruptive. And this is all concerning the dignity of the court and the authority that is necessary for us to resolve issues in a nonviolent, higher educational level method that the justice system is supposed to be a part of. Now, the question becomes whether this occurred in the presence of the court. And this court decision ex parte Daniels, 722 Southwest Second, 707, which is a 1987 case. Decision by the Court of Criminal Appeals in Bonk, that is the whole court made this decision because they felt it was important that all the judges be heard in the matter. And the issue became, did it happen in the presence of the court? If it's in the presence of the court, I can deal with it immediately, or I can postpone it like I've done and deal with it later. But in that special scenario, that's called a direct contempt proceeding, which the parties do not need a lawyer, aren't required to have a lawyer. This court can deal with it as soon as it's expedient. If it's not in the presence of the court, then it becomes what's called civil contempt, which still can be punitive, but in civil contempt, the parties are allowed an opportunity to hire a lawyer and can deal with it at a subsequent time. However, this was a case that occurred dramatically similar to the situation here. The question becomes, what does in the presence of the court mean? And the Court of Criminal Appeals ruled this way. The presence of the court does not necessarily mean in the immediate presence of the trial judge. The judge has, the court has held that the court is present and things happen in the presence of the court whenever any of its constituent parts, the courtroom, the jury room, or the doorway, are involved in are all involved in the work of the court. And it is for this determination and reason that the courts have held that you can be committed to direct contempt proceedings when someone is just placing publications, contemptuous publications, in the corridors of the courthouse where prospective jurors would necessarily see them. I mean, that's the far range aspect of how this court can have authority. We're not talking about people setting publications in the corridors of the courthouse that might affect jurors. What we had here was a fight going on at the doorway of this courtroom after the court had just immediately received a verdict finding the defendant guilty, and people related to the defendant and the victim were scuffling, and in the midst of an assault, it also interrupted the proceedings that the court was holding with Mr. Grove and his client, which had to be postponed and still, and then were disposed of at a later time. And then the court also lost its bailiffs that are required to be present at all times in this courtroom during its business, as they went out to immediately stop the scuffle and deal with the problem that it was having to deal with. So what this means altogether is this works just as though y'all had fought in front of me. Because we had that murder case, and then we went into another murder case and just completed that second murder case last night, I've asked the parties to come before the court. The court, because it was having to deal with those more important matters at the time, did bring the parties present, then postponed further proceedings. But it's the court's finding that these are direct contempt proceedings, and this court can make its decision. Did anybody stay in court, in jail overnight? Mr. Angel, how long were you in jail before you posted your bond?
Yeah, about 2 o'clock
A few hours?
overnight and the next.
It was overnight?
couple
Okay.
hours.
What about y'all,
We stayed about 7,
sir?
about 7 o'clock that night.
That night, okay. But y'all were arrested, brought to jail, and then,
Yes.
The damage done by this ridiculous behavior is 509, ended up costing $519.26 to the people of the taxpayers of Jefferson County. So each of you are going to pay your part. That's $175 each. Everybody, you, Mr. Angel, and Mr. Nicholas and Mr. Nicholas, you will be ordered to pay restitution to Jefferson County. The taxpayers, Jefferson County, the county treasurer had to buy the new equipment that is now placed out there. You will be ordered to pay that. Do you understand, everybody?
Yes, sir.
When can y'all pay that?
I pay today.
How about you, Mr. Angel? How much time do you need?
Feel the taxpayers, if you want to implicate them.
No, I'm not implicating
Taxpayers-
them. They're getting paid back for the
All right,
loss.
and listen, the taxpayers' time is not only cash, money is not only cash, but time is money. And money is time. So I feel they can get that back from me through time.
You're still going to pay the restitution. Do you understand?
I will.
Okay. Each of you will be ordered to serve 3 days in jail. 3 days in jail. Does everybody understand?
Yes.
Everybody understand? It's and ordered to pay restitution in the amount of $175. You'll be given, you've already served 1 day. I give credit for 1 day for each of you. So when can y'all begin the service?
Can I start it? Can I turn myself in tomorrow?
Sir?
Can I turn myself in tomorrow?
Yes, sir.
I just started school this week and I want.
Yes, sir. That's just 2 more days. 2 more days. When can you go, Mr. Angel?
Today.
All right. And
I need to call my job and everything.
yes, sir. Okay. All right. Do that and let me know, and then we'll work with y'all. Also, a part of the judgment, again, each person pays $175. That was put into the equation, so the court decided you didn't need to do 6 months. But the taxpayers, we all, including you, all of us are taxpayers one way or the other in this county. But we all pay our part. When tax revenue, assets are damaged, person responsible for it, the people responsible need to pay back for the people. So the court will order each of you to pay $175. And if everybody's credited for 1 day, 2 more days at on a time that y'all can work with. And we need to know, again, Mr. Nicholas, on you, you're going to, Mr. Angel says he's going to turn himself in on or before 6 o'clock today.
No, I'm just taking it from here.
Well, do you want to turn, you're going to get credit for the day, but you can stay out until 6.
All right, we can do that.
Okay. But on or before
No,
6 o'clock. Yeah, your word's good enough. what about Mr. Nicholas and Mr. Nicholas?
Tomorrow.
Okay, tomorrow?
Yes, sir.
All right, and then you'll, that just gives you 2 more days. But please, and also, when are y'all gonna pay this restitution back? You said today?
I can pay it right now.
Okay, well, I'm not sure how that,
Judge, I'm not quite sure.
I think that-
We collect the money. I'm gonna have to make some phone calls.
I think the jail normally does that. Don't the jail collect on restitution when they're?
No, I don't think so.
No, the jail doesn't collect any money and I can't take in any money on behalf of the court. I'm gonna have to make some phone calls. If everyone can just hang tight, let me figure out how we can get the money from.
Yeah, let's figure that out because this is kind of unusual. And so we can get it done right, okay?
So if everyone can just hang tight for about an hour, let me try to figure out how to get that and get the paperwork done for them.
Okay,
And-
you can work on that right now?
Yeah,
Thanks.
yeah,
Just
you know.
hang loose, not an hour, just about 20 minutes. We ought to have an answer, okay? All right. Yes, sir.
I want to apologize to you.
That's all right. That's all right. It's tough for everybody. It's tough for everybody. But every case we have, I've had 600 jury trials here. 600 I've presided over. It's hard on everybody. But the worst thing you have is to have show violence here in the courthouse when we're trying to resolve problems in a modern, sophisticated way. Now, people aren't always happy with the way things happen, but it's under rules, the rules of evidence. I helped write the rules of evidence, the Code of Criminal Procedure. There's rules. We're not cavemen that go out there and just seek our own way of justice. I mean, it's under rules, or it would be chaos. And we've developed it because that's why we're the leading country on the planet. People want to be like us in the way we resolve problems. But this building is filled with problems that we're having to resolve. And a lot of it is very emotional. Then nobody can appreciate it more. Everybody needs to know. I was in the United States Attorney's Office. I was the United States Attorney for 20 years before this. And then here going on 20 years. And James Byrd trial, I'm right in the middle of that, prosecuting that. You want to talk about emotion. Nothing was more, has impacted my life and this country than what happened in the James Byrd matter. But how did we dispose of it? How did we resolve it? We didn't just go out and just start fighting and disrupting and seeking immediate justice. We did it in an orderly fashion. And at the end of the day, people were executed under rules of order. Mr. Byrd didn't get that. I mean, he was brutally murdered for no reason except for his race. And that's one of the rules. We're all in this together, all of us. We all look different, unique. We're all unique people, all of us. But we're also fellow Americans and citizens that have to live together, not only on this planet, but in this country and deal with our problems. All of us have problems, every one of us. There was no perfection in it, but we've got the thing we have that's important is we have each other that we try to get along with. And because we're stronger when we work as a team, as a unit, all shapes, sizes, and colors. And these are emotional things that occur. But when we lose our focus and then resort to violence, then the rules aren't applicable anymore. And people get hurt, and it's a bad example. And it's certainly not anything that we want this courthouse and our county to be known for. It's known for justice. That's the kind of thing that it was meant to be. Just when something bad like that happens with James Byrd, you don't just take it into your own hands. You work it deliberately under the rules and make sure that justice is served. That's what the Attorney General ordered me to do, is see that justice is done and make sure that that those people are held accountable and fairness, but justice is served. Yes, I think I saluted that lady because she was that kind of lady. She was a general. But it works. I've seen it work. I know how it works. And when something like this happens, that's just a bad example to set. But yeah, I've been upset. Everybody loses composure. You lost composure. Okay. We're fixing this. We move on. We do better, get this behind us, and be the best we can be. Anything else? Awesome. All right, let's live together, try to live together and work through this, because we've got winners and losers and victims all the way around here, and we'll put everything back together and move forward as best we can, peaceably. Right? Yeah, everybody. That's what's right. And here we got families. Y'all know each other. And like I said, my grandmother, my grandparents, my dad grew up about a block or two from where this happened. And so I was over there all the time. I played in Gillum Circle all growing up as a little big kid. And it's not supposed to be a place where there's 88 people shoot 88 times in the residence area in a neighborhood. It's supposed to stand for something better than that. People go to live together peaceably as best we can with all our differences. Still, we're fellow human beings and fellow citizens. All right. Anything else? That is all. When we're in recess. Thank you.
Okay, so obviously we'll have more to say on this whole situation this evening at 8 a.m. Eastern, 8 a.m. I keep saying that because I do a morning show, 8 p.m. Eastern, 5 p.m. Pacific. I'll be joined by 3 of our channel members, and we will discuss this whole situation and our thoughts on it. Let's stay in Texas. We'll go back to Judge Boyd.
Kawazoe. All right. Court is calling 2024 CR 006945B State versus Jacob Kawazoe. Could I have parties announced?
Jason Garahan for the state, Your Honor. And Eric DeWalt. I represent Mr. Kawazoe.
And are you Mr. Kawazoe?
Yes, ma'am.
Are there any applications in this case?
There are not, Your Honor.
All right, counsel, have you received all discovery? Did you review it with your client?
Yes, and yes, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Kawazoe, did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
I do, Your Honor.
State, are you proceeding on the indictment as presented?
Yes, we are, Your Honor.
Mr. Kawazoe, did you review the court admonishments and waivers with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Did you understand you're charged with murder? The range of punishment is anywhere from 5 to 99 years or life in prison and up to a $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent. Did you understand by entering this plea you were giving up those rights?
Yes, ma'am.
Did you intend to give up those rights and enter into a plea in this case?
Yes.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Kawazoe, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No.
Anyone promised you anything other than the plea?
No.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes.
According to the plea, punishment is to be assessed at 20 years in the prison. There's an affirmative finding of deadly weapon. There are no applications. The state will take in consideration 2024 CC 007178, 2024 CR 006961. Did you understand that to be the plea?
Yes, ma'am.
Defense?
Yes, Your Honor.
State?
It is, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes.
Again, did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand? Counsel, have there been any such motions?
No, Your Honor.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence.
Yes, Your Honor. State Exhibit number 1 with office attachments.
We've had an opportunity to go over that. No objection. Admittance.
All right, did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call in the right to remain silent?
Do I repeat the question?
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine any witnesses the state will call in the right to remain silent?
Yes.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. All right. So I was going to ask, because I always look at plea bargain agreements to see if offers are appropriate in specific cases or offers that I will accept. So I've read the police report and I understand the issues that are presented for the state and for the defense, both good and bad. So after reviewing states exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty and the court will find you guilty. Are you proceeding with sentencing?
Please, Your Honor.
Anything you wish to say on behalf of your client?
Your Honor, my client is just asking that he hopes you will follow this plea agreement worked on by the state. It's been long and drawn out. My client has been cooperative with me the whole way through, and he understands what he signed to.
All right. Court will find you guilty as previously stated, sentence you to 20 years in the prison. Credit for any time served. There's an affirmative finding of deadly weapon. Taking consideration 2024 CC 007178 and 2024 CR 006961. Is there anything else with regards to sentencing?
Judge, just if for purposes of victim impact, we're asking for him to be on hold to send the TDC, at least come back to court on Tuesday of this coming week, which I believe is July 28th.
Yes. No. July 28th is a Monday.
July 29th.
July 29th?
Yes, Your Honor.
So Norma, make sure there's a hold on him. And it'll be recalled July 29th. All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, we can go off the record. Here's the thing. Any time that you do in prison or in custody, that's a lot of time. But you need to figure out how you ended up in this situation and change your life. Otherwise, what's going to end up happening, you're going to spend the rest of your life in somebody's prison and things will not go well for you. Do you understand?
Yes, ma'am.
And this is what I mean when I tell people, involved in drug transactions or using drugs, only one or two things going to end up happening. Either you're going to end up spending the rest of your life in prison, or either somebody's going to end up dead, either from using drugs or selling drugs, and somebody's going to have to identify the body. You understand? All right, and we are off the record. Judge.
So while she's muted herself a minute, breaking news. It's been a busy week for celebrity deaths, unfortunately. We had Malcolm Jamal Warner earlier this week, Ozzy Osbourne. It's now being reported that Hulk Hogan has passed away today. So that's sad. These are people we've grown up with, and they're leaving us. This is how you know you're getting old, when the people that you grew up with start to pass. So yeah, Hulk Hogan has died today. Let's go back to Judge. Hopefully she unmutes here momentarily.
Steve, for victim impact. All right, thank you.
Your Honor, once again, thank you for your consideration.
You're welcome. Have a good one. Tell you, why wasn't your daughter up here?
He was with me along this whole time.
Okay.
She was here the whole way through.
All right, let's check in on our bird friends for a moment. And it looks like they've all flown away. They come and they go. There's it's actually quite a lot of action on this feed, but they seem to come in groups and then they go away in groups. So we'll continue to keep an eye. Let's go. Well, it's been a minute since we've been here. Oh, see, birds are back. There you go. Told you. It's been a minute. Let's go back up to Michigan and spend a few minutes with Judge Mom.
That's you, Mr. Goldbach.
Oh, I'm sorry. Yes, I apologize. Good afternoon, Your Honor. John Goldflaw. Your Honor, John Goldflaw, P 30758, on behalf of Mr. Newmark. Today was taking time set for a pretrial in this particular matter. Your Honor, I've had lengthy discussions with Mr. Newmark. I've also had lengthy discussions with immigration attorneys over in Canada. We're asking for an interim of approximately 30 days, 30 days for data. I will be back here to adjourn this pretrial for the discovery. I've never received the discovery because of circumstances. I spoke with the prosecutor today. He indicated that it was sent, I guess,
You're not talking in court, please.
originally to Mr. Serrano. However, I was unaware of that. I don't know why I might have gone there, but he's indicated he has now sent this to me. Second of all, Your Honor, we have to, after further discussions, and I've been discussing this with the prosecutor last week, we have to do a deviation letter. An attorney or immigration people that I've spoken to, he is going to have a letter explaining everything regarding the possibility of being deported, for lack of a better term, based on any type of conviction for alcohol. Originally, there was a plea offer made, which would have been accepted. However,
This court did not accept it.
No,
so
it
that
didn't.
Mr. Newmark could research.
and that's what we've been doing. He did contact a couple of times, and he's indicated to me that he has now retained that individual. He will be sending me all that information so I can put that into my deviation letter to Mr. Brezhnev. Before 2018, there wouldn't be this problem. And Mr. Newmark is a resident of Canada, correct?
Yeah.
But is not a citizen. He's married to a Canadian citizen.
Yeah.
Has resided there for a number of years, but has never obtained full citizenship. And that's the problem.
Okay.
I've checked my calendar, Your Honor, and I believe I am back here on the 20th. If that would be acceptable to the court.
Well, we don't have a document that day. Well, the
And I guess
20th,
I'm not going to be here.
the 20th is a Wednesday.
Oh, I'm sorry.
So,
Well, maybe the 21st. I can go back and look on my phone, but I don't want it to go off.
August 28th at 9 a.m.
Thank you very much, Your Honor.
Does that work, Ellie? Yeah. And your conditions are continued. If you were to test today, sir, what is in your system?
Prescription drugs.
All right. Okay. All right, thank you.
Thank you very much, Your Honor.
Thank you.
Okay. I'll get this stuff to you. You'll give me a call. Okay.
All right. Okay, there's that one. All right, we are on the record in the matter of the state of Michigan versus Cornelius Jett, 25975. And I'm also seeing 25976, but I don't have that on here.
Your Honor, I have that. He just handed me that file a while ago. I've been trying to get into Zoom. And I've spoken to, it didn't happen.
Okay, well, Mr. Jett is in a breakout room now.
Okay.
Did you log in?
I logged in. And it said,
So-
others as well.
Mr. Collins, we're waiting for Mr. Jett to come back into the main room so we can handle the phone.
See, who's there now? I'll go look, talk to him right away. I wasn't.
Okay, we're gonna recall Mr. Jett. We're on the record in the matter of the state of Michigan versus Carlotta Slater,
Right.
25750.
Good afternoon, Your Honor. Greg Bulahanis, P 36431. Your Honor, I think it's the city of Riverview.
Where did I say, the state of Michigan?
Yes, sure.
Riverview, it is, yes.
We've had a chance to read the pre-sentence report is accurate. We'd ask the court to adopt its recommendation. Additionally, Your Honor, you should see attached to the pre-sentence report, there's a certificate of completion for the alcohol highway safety program that my client did on May 17th.
Yes.
And so I asked the court to follow the pre-sentence report recommendation, and as the court's aware of my client, this is a first offense. She has no prior arrest. She's recently undergone radiation therapy for cancer.
Okay.
And we'd ask the court to assess her fines and costs in this case.
Okay.
As recommended.
All right.
She scored a 1 on both.
Carlotta Slater. Thank you. What?
She scored a 1 on both needs tests.
Oh, she scored a 1, yes, yes, okay. All right, and so this is, today's the date scheduled for sentencing on your client's charge of reckless driving. And the court will note after reviewing the report and recommendation hearing from counsel that there is not reasonable grounds for Department MCL 769.5, and the court's going to not place your client on probation. The court's going to order fines and costs. The court's going to order a $500 fine, $100 screening assessment fee, cost of prosecution $300, crime victim assessment fee of $75, justice system assessment fee of $50, for a total of $1,025. And how much are you able to pay per month, and what works best for you?
I can pay off
Can she have
Off
a,
today?
can she have a week, Your Honor? This is a week,
That's good.
1 week, Your Honor,
Okay.
to pay everything.
All right, so, we'll do August 1st. It's a week from tomorrow. How's that? That's okay.
Thank you, Your Honor.
All right, thank you very much. I'm going to have to go back over the probation just in case you have to get something from them, okay? All right, good luck to you.
Thanks.
Thank you. Have a good day.
You too.
All right, we're on the record in the matters of the state of Michigan for Kevin Pincava, 2591-25969.
Good morning, Your Honor. Well, good afternoon, Your Honor. Najad Mihan appearing on behalf of Mr. Kevin P59371.
All right, thank you. And Mr. Pincava, your name, please. Mr. Pincava?
Kevin Michael Pincava.
All right. And today's date scheduled for the probable cause conference on both of these, one of which your client failed to appear for, and there was a warrant that had been issued. And counsel, what's happening today?
My client's going to waive his right to an exam on both cases.
All right, and so Mr. Pincava, you understand that you do have the right to have a preliminary examination, and it must be shown that crime was committed and probable cause exists to charge you with that crime, correct?
Correct.
And you also understand that by entering into by waiving your right to preliminary examination, you will be bound to the circuit court for
Yes,
further
Your-
proceedings on the charges and complete you are correct?
Yes, Your Honor.
And you have in fact received notice of those charges that are complete warrant. Is that also correct?
Correct, Your Honor.
Has anybody promised you anything, threatened you or coerced you in any way to waive your right to your preliminary examination?
No, Your Honor.
All right, the court will note that it has waived his right to preliminary examination. The court will bind defendant over to Third Circuit Court. You are to appear in Circuit Court on July 31st at 9 a.m. on the charges in the complaint warrant. Counsel, do you have any objection to the court indicating via Zoom on both your signature line and your client's signature line?
No, Judge, no objection.
All right, the conditions will continue. Anything else?
Yes, can we please have a referral for a DSU report?
Okay. I will put that referral in.
Thank you, Judge. Have a good day.
Thank you, you as well.
Thank you, Your Honor.
Thank you. Let's go off the record.
Mr. Jett, can you please rejoin the breakout room so you can finish speaking with the attorney?
Yes, I'm unmuted.
Yes, Mr. Jett went back into the breakout room with the other attorneys, so I can call both cases at the same time.
Thank you, Judge.
Thank you.
All right, let's switch it up and go to another place that we haven't been in a while. Let's go to Fulton County, Georgia. This is Judge Lal.
Our state all-purpose calendar with the State Court of Fulton County. These are misdemeanor cases in which individuals were recently accused of misdemeanor charges. First appearance has been held for most of the cases, and bonds have already been issued. Today, the defendant is going to advise the court as to how he or she would like to proceed with their cases. They all have been appointed counsel, they've had an opportunity to speak with their attorney, and the defendant would then let us know whether they would like to accept a plea offer from the state or enter a not guilty plea and proceed with trial. So please remember that during the course of this virtual proceeding that's not only being recorded but live streamed, you have a right to remain silent. Anything you choose to say about the facts of your case during the course of this proceeding, your statements can and will be used against you. You have a right to an attorney. If you cannot afford one, one will be appointed to represent you. Who do we have, Mr. Haddad?
Your Honor, position number 55, Drayton Williams. I did have an opportunity to speak to him this morning, Judge, and I did not get a chance to ask Mr. Falk, or at least inform the court. We're requesting a NOLO plea on that case, but we're accepting the negotiated plea as is, but we are requesting a NOLO plea. And I'm sorry, Ms. Harrison, apparently, is the prosecutor on that case.
All right. It's a simple battery charge from July 9th, case number 25 CR 3928J. And Mr. Williams has been advised of his rights. Ms. Harrison, any objection to a NOLO plea?
Your Honor, I was gonna check and just make sure that he's eligible, but I believe that it might be okay. Give me about a minute. Pull back.
One more.
Yeah.
Looks like this was it a rooming house situation or just a
That's an apartment, Judge.
apartment? Okay. Is pre-trial on Zoom?
Yes, Your Honor. I
Ms.
do not
Washington?
see any NOLO pleas in the last 5 years. There was an arrest in 2018 for domestic battery out of Nevada, and it lists as like community service. It doesn't have a disposition that it was a conviction. And there was also a domestic battery, I believe, out of Florida, but that was from 2012, a conviction.
Thank you, Ms. Washington. Any objection, Ms. Harrison?
No objections, Your Honor. The state's recommendation is 12 months, probation served 28 days, credit for time served 14 days. The defendant has been incarcerated since July 11th. Completion of 40 hours of community service, no further contact with Charles Rogers, a stay away from 3263 Greenbrier Parkway, and no firearms. We would like to sound for Mr. Charles Rogers, and we ask that the defendant stipulate to venue, ID, and facts of the case for purposes of the plea, Your Honor. And that'll be all for the state.
All right, Mr. Rogers, are you on the Zoom? All right. And Mr. Haddad, do you so stipulate?
We stipulate for purpose of the plea, Judge. We just ask the court to follow the state's recommendation as is, and in fact, need to fill in on the facts. I'd be happy to, but I would just ask the court to accept the negotiated plea, Judge.
Mr. Williams, please raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge? All right. You just need to speak up when I ask certain questions. Have you consumed any medicine or alcohol recently?
Medicine, yes.
And are you still able to understand what's going on?
Sure.
Yes or no?
Yes.
Are you satisfied with your attorney?
Yes.
You're fading out. I can't hear you.
Yes.
Okay. So if you plea, you would have to give up your right to a trial in front of a judge or a jury. You will not be able to go back to court to confront your accuser, challenge the evidence brought against you, be able to present your own defenses and arguments, and the prosecutor won't have to prove the charge beyond a reasonable doubt. Are you prepared to give up these rights?
Yeah.
How do you plead to one count of simple battery?
No.
Accept your nolo contendere plea, and your sentence will be 12 months to serve 28 days, credit for time served 14 days. You will report to the probation office on Monday. I think it's the 20.
Your Honor, I apologize. He has a hold from Gwinnett. What I've instructed him is once he's released from Gwinnett, he'll have to report to probation at 132 Mitchell Street, Judge.
Okay. Once he has resolved his holds in other jurisdictions, he has to report to Fulton County probation within 48 hours. While on probation, he will complete 40 hours of community service at a minimum rate of 5 hours per month. And this will be at any nonprofit agency that's not a church and not a school. He is to stay 200 yards away from Charles Rogers and not have any communication or contact with him, and stay away from 3263 Greenbrier Parkway in Atlanta, Georgia. He's not allowed to own or possess any firearms. Does he have any property at Greenbrier Parkway?
Yes, he does, Judge, and I would request a one trip with law enforcement to retrieve his belongings, Judge.
He's allowed a one-time visit with a police officer, and he must first stop at the leasing office and get instructions from them. At all times, he must be accompanied by the police officer. That visit cannot exceed 1 hour.
Thank you, Judge.
All right, thank you. Next case.
Mr. Webb. I'm ready on position 50, 50, and 51. Carlton Webb.
Okay.
I think position 53 is a failure, or 52 and 53 are the failures to appear. But I'm ready on the two mentioned, Judge.
Yeah. He's got 4 positions, and the last 2 would be null pros in the event the plea goes forward.
That's correct, Your Honor.
Okay. So this is Carlton Webb. Mr. Webb has got 4 matters before the court. Please remember your rights to remain silent, and your attorney is Mr. Haddad. 23 CR 7563B is theft by deception. 19 CR 6784J is 1 count of battery, 1 count of battery, family violence, and cruelty in the 3rd degree. And the 2 other positions are bench warrants. Ms. Harrison, what's the recommendation for position 50 and 51?
Your Honor, for position 50, the state's recommendation is 12 months served, 48 days, credit for time served, 24 days. Defendant was incarcerated November 29th of 2023 to December 6th of 2023, and then from July 9th of 2025. The balance will be probated, completion of an anti-theft course, restitution to the victim, 40 hours of community service, no further contact with Tyler Cummins, a stay away from 120 North Avenue. And this is a global recommendation with 19CR006784J, which is position 50. Count 1 battery will merge battery, family violence. The state's recommendation is 12 months served, 90 days, credit for time served, 33 days. Defendant was incarcerated August 8th of 2019 through August 10th, and then August 24th of 2023 through September 6th of 2023, and then again on July 9th. The balance will be probated, completion of a family violence intervention program, 40 hours of community service, no further contact with Kiana Williams, a stay away from 3144 Martin Luther King Drive, no firearms, and count 3 will be 12 months probation consecutive to count 2. And we will sound for Ms. Williams at this time, but we ask that the defendant stipulate to venue, ID, and facts of the case for purposes of the plea.
I don't see Ms. Williams on Zoom. Mr. Haddad, does your client accept the terms and with the understanding that he'll be on probation for up to 2 years? And do you stipulate to the factual basis of venue and ID?
Judge, we stipulate to factual basis, venue, and ID. I would just ask the court to consider non-reporting after a year, assuming all the conditions are that he's in compliance, Judge.
Any objection?
We have no objection, Your Honor, and I do want to note for the record, the restitution amount in position 50 is $76.
$76. Okay.
I've discussed that amount with my client since it's based on the report, Judge.
Okay. Mr. Webb, please raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, Your Honor.
Have you consumed any medicine or alcohol?
No, Your Honor.
And have you understood what's going on in your cases?
Yes, Your Honor.
Are you prepared, are you satisfied with your attorney?
Yes, Your Honor.
And if you decide to enter this plea to these two cases, you would have to give up your right to a trial. You will not go back to court to face your accuser, challenge the evidence brought against you, and the prosecution won't have to prove the charges beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, Your Honor.
How do you plead to theft by deception from November 27th, 2023?
Guilty.
Repeat.
Guilty.
Your sentence is 12 months to serve 48 days, credit for time served 24 days. You'll report to probation on Monday before 3 p.m. And while you're on probation, you will enroll and complete an anti-theft class, pay $76 in restitution, do 40 hours of community service at any nonprofit agency at a minimum rate of 5 hours per month. At all times, you're to have no contact with Tyler Cummins and stay away from 120 North Avenue. With regards to 19 CR 6784J, how do you plead to battery, family violence, and cruelty in the third degree?
Guilty.
Count 1 battery will merge into count 2, which is battery, family violence. For battery, family violence, that particular sentence will be concurrent with the previous case. And for count 2, the sentence is 12 months to serve 90 days, credit for time served 33 days, which means you'll have additional jail time. That would, of course, postpone your visit to probation. After the additional jail time is completed, you will then report to probation within 48 hours of being released. While on probation, in addition to the other conditions I've mentioned, you will also complete a domestic violence intervention program, which is a series of 24 classes that you will have to complete at your expense. The 40 hours of community service will be the same 40 hours I've just previously mentioned at any nonprofit agency that's not a church and school. In this particular case, you're to have no contact with Keona Williams and stay away from 3144 Martin Luther King Drive. At all times, you're not allowed to own, possess, or have any firearms. With regards to the cruelty in the third degree, count 3, that would be a consecutive term of probation, and that would be 12 months of probation. If you have completed all your conditions and you are up to date with your probation fees, then for count 3, cruelty in the third degree, your probation may be non-reporting.
Thank you, Judge. Andrea Reed. Mr. Reed?
Oh, and his bench warrants, positions 52 and 53 are null prost. What's the next case?
On a position number 44, Andrea Reed. Andrea, I apologize. Andrea Reed, Judge. That's ready for a plea, Judge. The only change, it's going to end up being time served because he's been in custody for longer than indicated in the plea recommendation, Judge.
Let me see. So count 3, simple battery would be 12 months probation consecutive. And count 2 will merge with count 1. So he'll be pleading guilty if he moves forward to 2 counts. And what did you say? It's 45 days credit for time served, 15 days. So is that going to be amended?
Yes, Judge. He's been in custody since May 30th. So it's in essence, it's a time served sentence, Judge.
Let me see.
And I had Ms. Falk agreed with my assessment, Judge.
All right.
Your Honor, long story short, the defendant was arrested on May 30th. The warrant was not actually put on the system until July 11th, but it was for an incident that happened in April of 2025. So hypothetically, the warrant should have been levied on him when he was arrested on his other charges.
So is this going to be 12 months to serve 45 days, credit for time served 23 days?
That should be correct, yes. Well, no, it should be more credit for time served than that because he was arrested on May 30th. So that actually should be
30, 54 days?
56 days, according to the jail system.
So
Your Honor,
what?
I'm sorry, Judge. I would just ask perhaps to sentence him to 56 days with credit for 56 days.
That would be fine.
That's how long he's been in, so.
Credit for time served 56 days, all right? Does he have any other holds or matters at the jail?
Your Honor, let me just double check. Your Honor, he has a case, still a felony case here in Fulton County. He's got, I'm not sure exactly when his court date is, but he also has a Clayton County hold. So, and then what I've instructed him is upon release, wherever he's released from, he'll have to report to probation either 24 or 48 hours, or as the court instructs accordingly.
I see that he was booked in on a robbery charge on April 10 or May 30th, and he's got a hold. Did you say Clayton County?
Yes, Judge, according to my notes.
Clayton County, okay. So what would we like to do today?
We're ready for a plea, Judge.
Okay. This is Andrea Reed, case number 25 CR 003923F. Mr. Reed was originally booked in with 2 counts of battery and 3 counts of simple battery from April 15th, 2025. Mr. Reed, you've been advised of your right to remain silent. Your attorney is Mr. Haddad. May I place you under oath for the plea? Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge? You need to say yes or no for our court reporter.
He did say yes, Judge.
Yes.
Thank you. All right. So, Ms. Harrison, what's the recommendation for count 1 and count 3?
Your Honor, count 1 will be time served, 56 days, credit for time served, 56 days. I believe the defendant has been incarcerated since May 30th. The balance, well, okay.
Are we still going on probation?
He has holds.
Well, once he's released from the hold, then he reports to probation.
Yeah, we will still go with that, Your Honor.
So you're still pursuing probation?
Yes.
Okay, so what is the terms of probation?
So the balance will be probated, an 8-week anger management course, 40 hours of community service, no further contact with George Cook, a stay away from 1960 Allison Court, Southwest Atlanta, and count 3 will be the 12 months probation consecutive with count 1. And we ask that the defendant stipulate to venue, ID, and facts of the case for purposes of the plea.
And Your Honor, we stipulate, just ask the court to consider non-reporting upon completion of all conditions, or at the very least after 12 months, Judge.
I will. As if he's resolved all his other holes, then that should be fine.
Thank you.
The state has no objection.
Thank you. All right. Mr. Reed, have you consumed any medicine or alcohol recently?
No.
Have you understood what's going on in your case?
Yes.
And are you satisfied with your attorney?
Yes.
You understand that if you decide to plead guilty to these 2 charges, you would have to give up your constitutional right to a trial in front of a judge or a jury. You won't be going back to a court of law to face your accuser, challenge the evidence brought against you, present your own defenses and arguments through your counsel, and have the state prove the charges beyond a reasonable doubt. Are you prepared to give up these rights?
Yes.
How do you plead to 1 count of battery and 1 count of simple battery from from April 15th, 2025?
Guilty.
Your sentence for the battery charge is going to be 12 months to serve 56 days, credit for time served 56 days. Once you have resolved your holds either at the Fulton County Jail and or any other jurisdiction, you will then report to the Fulton County Probation within 48 hours of being released. You will begin your probation with completing 8 anger management classes, 40 hours of voluntary community service at any nonprofit agency that's not a church and not a school. Have no contact with George Cook. Stay 200 yards away from Mr. Cook, and stay 200 yards away from 1960 Allison Court in Southwest Atlanta. Count 2, battery, will merge with count 1. Count 3, simple battery, your sentence will be 12 months probation, consecutive with count 1. This probation may be considered non-reporting if you have completed all your conditions from count 1 and you are up to date with all probation fees and court costs. For the count 4 and count 5, these charges will merge into count 3. Thank you.
Thank you, Judge. Is the Rico Hudson here?
Your Honor, excuse me, did probation become non-reporting?
Only if he completes all his conditions from count 1 and probation fees are up to date.
Yes, ma'am.
And who do you have, Mr. Haddad?
You're on position number 33 and 34, the Rico Hudson, Judge.
Okay. Rico Hudson is accused of battery, family violence, willful obstruction, and disorderly conduct, 24 CR 820Y from February 16th of 2024. He has a bench warrant 25 FTA 1327 from April 4th, 2024. Mr. Hudson, for purposes of the plea, may I place you under oath? Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes.
Repeat.
Yes, Your Honor.
Thank you. Ms. Falk or Ms. Harrison?
Your Honor, I neglected to add ASG Harrison to the email I sent Mr. Haddad because I was moving a little fast. Just to let ASG Harrison know, we have agreed to do a one-time law enforcement escort to the location of Holly Street Northwest. The defendant can take possession of the residence if Miss Lisa Cruz does not reside there. Thank you.
Thank you. Your Honor, the state's recommendation for count 1, battery, family violence, is 12 months, served 45 days, credit for time served 23 days. Defendant was incarcerated February 17th through 19th of 2024, and again on July 5th. The balance will be probated, completion of a FVIP course, 40 hours of community service, no further contact with Lisa Cruz, stay away from 236 Holly Street Northwest with the exception of a one-time police escort, and the defendant can take residence if Ms. Cruz is not there. Count 2, willful obstruction, is 12 months probation consecutive with count 1, completion of 40 hours of community service and a $300 fine, and count 3 will merge with count 2. And we ask that the defendant stipulates a venue, ID, and facts of the case for purposes of the plea. We would also just like to sound for Ms. Cruz out of an abundance of caution in accordance with Marcy's law. And that'll be all for the state.
Lisa Cruz, if you're on Zoom, this is the time to unmute and start your video. And Mr. Haddad, do you so stipulate?
I would stipulate, Judge.
All right. And just to clarify, Mr. Hudson was in custody for 2 days in 2024, and then he was rearrested on July 5th of this year. So didn't want to leave the impression he's been in custody since 2024. Mr. Hudson, have you consumed any medicine or alcohol recently?
No.
And have you understood what's going on in your case?
No.
Are you satisfied with your attorney?
No.
If you decide to plead guilty to 2 of these charges, you would have to give up your right to a trial, to be able to confront your accuser, challenge the evidence brought against you, and have the state prove the charges beyond a reasonable doubt. Are you prepared to give up these rights?
No.
Repeat.
Yes.
How do you plead to 1 count of battery, family violence, and 1 count of willful obstruction of an officer?
Guilty.
Count 3, disorderly conduct, will merge into count 2. For the battery, family violence, your sentence is going to be 12 months, to serve 45 days, credit for time served 23 days. If you have no other holds, you will report to probation on Monday before 3 p.m. You will enroll in a domestic violence program within 30 days of being released. You will complete 40 hours of community service at a minimum rate of 5 hours per month. You are to have no contact with Lisa Cruz and stay away from 236 Holly Street in Northwest Atlanta and not own and possess any firearms. Upon your release, you are allowed a one-time visit to the location at 236 Holly Street, and you must go there with a police officer. If the police officer verifies that the property is no longer occupied by Miss Lisa Cruz, you may then reclaim possession of the property if you are entitled to do so. I do not know if it's a rental property or whether it's his own home. What is the status of the property, Mr. Haddad?
I was told that it was a family home, his family's home. I did not inquire whether it's an apartment or an actual single. He says it's an actual house, Judge. It's not. Okay.
No, hold on. Your mom's house is still down? Does Miss Cruz live there? No. Okay, she live next door? No.
Okay. All right. My client's mother lives 2 houses down. It sounds like the incident location was, she does not, that 236 Holly Street, Judge, is not my client's mother's address. And on the warrants, Judge, I think it's like 245 Holly Street. That's where my client lives. I suspect that the incident happened a couple houses down, but apparently Ms. Cruz does not live there. So, I guess we can put a stay away from 236, since he does not live there, nor does Ms. Cruz. That's what I was told. I have not, independently confirmed anything, but I do know that the warrant has a slightly different number on Holly Street, Judge. For my client, I'm sorry.
Ms. Falk, what was your understanding of this stay away?
Your Honor, my only understanding of this is that it was requested that he be able to go back to the stay away address. And because I'm unsure whether the victim still lives there or not, we asked that the address, that he have a one-time escort to make sure the victim does not reside there. Now, what I'm not sure about is if the address that is listed on the plea recommendation is actually the address where all of the parties were living at the time. I believe ASG Harrison may be able to look and let us know that.
Yes, I'm actually in it right now. Give me just one second. I got an error message from Odyssey. But Mr. Haddad, you said the address where his parents live on the Holly Street is 245?
The warrant has.
Well, let me ask you this. Where does Mama live?
Right.
254 Holly Street.
Okay.
Southwest.
254, and the warrant says 236. Okay. Mr. Haddad, has Mr. Hudson also resolved his current felony holds?
No, Judge, he still has that coming up. He's got a prelim scheduled for next week on that case, Judge. So what I've instructed him is the court may advise him as to when to report to probation upon a certain number of hours or days upon release from that charge, Judge.
Who's the alleged victim from the harassing communications?
Your Honor, the warrant alleges it's Ms. Cruz, and that's something that I've discussed with him as well.
Yeah, no. He's not going to be anywhere near Hudson. Anywhere near Holly Street.
Understood.
No. July 5th, harassing communications with Lisa Cruz by text messages. I'm reading this warrant. No, Mr. Haddad. He's got open felony charges with the same victim.
Judge, I'm not here to address the warrant. I'm not arguing any of that, Judge. I'm just, what I'm requesting, Judge, is that if the law enforcement can confirm that she does not live at,
I don't care whether she lives there or not.
the stay away is in effect, Judge. But it's his home. The court cannot, if she does not.
Yes, I can. He's got now I've got 3 felony charges involving the same victim. One of them is possession of firearm by a convicted felon. I can make him stay away from Holly Street.
Let me have a second.
He's trying to game us, Mr. Haddad, by asking that I'm not even happy with this plea now. So
I've explained it to my client, Judge, and stay away. I told them that this court is imposing a stay away from that Holly Street, Judge. And he has to abide by that.
all right. I'm removing the one-time visit to Holly Street. I'm removing, and he has to stay 200 yards away from 236 Holly Street. And if that involves 254 Holly Street, anywhere, as long as it's within a 200-yard gap, I don't want him anywhere on that street. If he wants to visit his mom can come visit him, but he can't go to that location.
Understood, Judge.
All right. So going back to the battery family violence sentencing, again, no further contact with Lisa Cruz. Not only is this not going to be a sentencing order, but he's also got that in his bond order from his felony case. He has to stay 200 yards away from her, not communicate with her in any way, form, or manner. And if he's seen anywhere near Holly Street, or if he attempts to communicate with her, this sentence will be revoked. With regards, and of course, no firearms. He's a convicted felon. He's not allowed to own, possess, or have any firearms. With regards to the willful obstruction, this is a 12-month consecutive sentence for probation, in which he will be required to complete an additional 40 hours of community service and pay a $300 fine. This means that once he has resolved his felony hold and any other holds that he has, he will report to probation within 48 hours and be on probation for up to 2 years, in which he'll be required to complete all these conditions, including the 80 hours of community service and the $300 fine. And no, I will not amend this to non-reporting.
Understood.
Count 3 will merge into count 2.
Thank you, Judge.
Good morning, Judge.
Morning.
All right, friends, let's call it a day with our birds here. Lots of action right now. I like birds. They're peaceful. They're fun. Though they do make a mess, I will tell you that much. So the next time you see us live will be tonight, 8 p.m. Eastern, 5 p.m. Pacific for our inaugural episode of Sidebar. It won't just be me. It will be channel members with me as well. So it'll be something different and something fun. And we're going to discuss the contempt of court that happened in Judge Stevens' courtroom last week that we saw a little bit of today as well. So look forward to seeing you all there. In the meantime, go have yourselves a great Thursday. Oh, by the way, in the pinned chat is the link for that show tonight. So if you go to that link, you can click the notify me button if you don't already have notifications turned on, and then you'll be alerted when we go live. But anyways, go have yourselves a great Thursday. Again, we'll see you tonight, 8 p.m. Eastern, 5 p.m. Pacific. In the meantime, take care and God bless.